Then I had to call the doctor, says, I can't come, sorry, we have to cancel it.
Oh,
So that is, so you should never keep some eatables in your desk. Unconsciously, Anyway.
may please alert. May please alert. Lordship, I'm paying for listing of this matter in the admission program, Lordship.
Madam, registry. Only new matters. Yes, yes, sir.
Daily is most of item number 1.
If they're not there, then go to the next. They're there. Give me.
Yes. On the last occasion, Lordship, there was submission made that we did not participate in the advertisement. We checked with the client after the matter was over. They participated in the
They
advertisement.
participated.
Participated. But the matter of fact remains that similarly situated individuals now, they're benefiting from a pay scale of 72,000 under 3 years. I have been left out. The Lordship had asked them to get instructions on the matter.
Who is the? You
Yes,
see,
that's
there is another issue here.
Yes, Your Lordship.
You have come by way of a writ.
Yes.
Is it? Anyway, since it has been acted upon.
And we have preferred numerous representations. There was
Okay, so is the list that has been issued
yes, Your Lordship.
made on the basis of the cabinet decision?
Yes. This is my humble submission. This was because all of those lecturers, they were all appointed in
Because to be enforceable, a
Yes.
cabinet decision to be enforceable
Yeah.
has to be crystallized by way of an order of the state government under the name of the governor,
Yes.
under 166.
Yes. But the list is a conclusion of the cabinet decision which took place. And all of these lecturers now,
But cabinet decision to be enforceable
yes, yes,
has to become an order.
that is,
So if it is, so whether a writ will lie unless there is an order.
the writ lies against the issuance of the order subject to what your lordship says, 22(1), that why my name was.
What to do? Actually, my mistake also, we changed the timing, 11:30 to 10.
Then maybe the matter can be taken up at maybe 11, subject to your lordship's convenience.
Yes, Mr. Sakia, you're here.
Mr. S. Das and K. Gogoi were in charge of the matter. The entire issue relating to the regularization of lecturers and professors in engineering.
S. Das and KP Pathak. Oh, Mr. Gogoi is here.
Lordship, after some time, Das is coming. Lordship. After some time.
Okay.
After.
Next.
Item 2.
Please, Your Lordship.
Yes, what do you want?
But here is a case where the petitioner's son, he died after 3 years, about 3 years of service. Now,
He died on 1?
6/6/2017.
Okay, so he's covered by that OM.
OM.
11470.
No, not that. Because what has happened, yes, he's covered the OM.
Yeah, he's covered by that.
He's covered with the OM.
So you want the compassionate family pension.
And she has been paid is 177,777 and odd.
Has your son got any wife,
No.
children, nothing? Yes.
He was unmarried.
Unmarried.
6. He's unmarried.
Okay, so let us see the OM.
My-
The OM, where is that OM?
My lord, OM, one is at page 18, my lord.
Page 18.
My lord.
Page 18. This is a 6. No. This will not apply.
No, this is where, my lord, because he comes as an NPS. So, my lord, that's why, my lord, this may be relevant.
No, you are asking for what? What is your prayer in the writ petition?
My lord, I am asking for, my lord, the family pension, my lord, that is to be given to me, my lord.
Family pension.
My lord.
Actually, you are not asking for compassionate family pension.
My compassion family. Compassion family pension. But then
There's a difference between
Yes,
family pension and
yes, but there's a
compassion.
difference, but then
So you are asking for compassionate
compassion
family
family pension. Compassion
in
family-
terms of the OM dated 17.
Yes, my lord, but then this is also relevant, my lord. That's what I'm saying.
How is it relevant?
Because, my lord, here I come on the NPS. I do not come on the OPS. So under this scheme, my lord, certain benefits were, my lord, provided.
Yes.
This is to be read in conjointly, my lord. Then, my lord, of course, 17 notification is also there, my lord.
Where, which part?
My lord, the governor of Assam is pleased to extend the following additional benefits, my lord.
Yeah.
Paragraph 4 onwards.
Yeah.
The state government servants coming within the purview of NPS, appointed on or after 1/1/2005, on getting discharge and invalidation, discharge or to the families of such employees covered by NPS who have died in harness since 1/2005, with a view to mitigating hardship meted out to them, to their families in the lines of Government of Indian provisional pension, only until further orders with the rules regulating these benefits under NPS are framed and enforceable. Then, my lord, these are the, my lord, benefits that will be, my lord, given to them under section rule, my lord, clause 5, my lord. Then, my lord, of course, this, my lord, 31st October 2017 notification, my lord. That comes, my lord.
So this 31st October 2017
My lord.
is only for those who are covered by the 1969 pension rules.
No, my lord, it has three different categories. In
Where
fact,
is
my lord,
that?
Lordship will see, my lord, there are three different categories, 1, 2, and 3. Lordship will find that at page, my lord, 26 is the type copy, my lord. First,
Yes.
my lord, family pension holders, cases covering death of government servants while in service appointed before 1/2005. Those will be covered, my lord, by the old policy, my lord. Then number 2, Lordship will find at serial number 2 is the next category, my lord, page 30. No, so I'm sorry, my lord, page 28, my lord, 29. The compassion family pension sanctioned to the family of government servant who died while in service on or after 1/4/2017 in lieu of compassion appointment provided till 31/3/2017. So she will be covered by this, madam. She will be getting these benefits. Page 29.
Yes, who's for the other side?
And then, my lord, what has happened here? The difficulty, my lord, because of this notification at page 40, the amount she has got, my lord, she wanted to refund this amount. But because of this 40, my lord, notification, she is not in a position to refund this amount.
No, just
Para 2, my lord, clause 2, my lord.
just a minute.
She was paid this amount, my lord, on 29/11/2017. Now she wants to refund this back
Why? Why?
because, my lord, she was not informed that she had got two options.
What options?
Either to opt for, my lord, that annuity, my lord, benefit, or for the, my lord, compassion family pension. For that purpose, lordship will see, my lord, there's another circular, that is page 36.
No, you have been given.
The annuity amount of 1,17,000 only, my lord.
And when did you take this money?
2017, my lord.
Oh, and now you come after 8
My
years.
lord, because what has happened, my lord, that's the thing, my lord. Lordship will see that, my lord, page 36, my lord. They had to, my lord, give me that option, my lord. She's a widow, my lord, widow, my lord, and then, my lord, she has lost a son, my lord. Page, my lord, 36.
We'll issue notice. Heard Mr. M. Dutta, learned counsel for the petitioner, who submits that the petitioner was not given the option for being given the benefit of compassionate family pension in terms of the OM dated
31/10/2017.
31/10/2017, and instead had been given what?
She had paid the benefit, annuity benefits, my lord, under the
She had been given the annuity benefits under the
NPS scheme, my lord.
NPS scheme.
My lord.
Issue notice returnable in 4 weeks. Mr. Who accepts?
I am for one.
What have you got to say out here in this case?
Let notice my go.
Mr. PK Bora accepts notice on behalf of
1, 4, 6, and 7.
1, 4, 6, and 7. Mr. P. Saikya, 3 and 5. Anybody else?
Finance is there.
Finance. Who is the pay for finance? Mr. A. Chaliha. For respondents number
2 and 8.
2 and
Eight.
8. This is the matter of the 4 weeks to enable the respondent to file the affidavit.
My lord, can I pray for a date, man? The pension matter, my lord.
You've already got the money anyway.
No, well, money, my lord, that's
Wait,
1
just
lakh
first time only, just wait.
1,17,000.
2025 matter, Mr. Kaun.
Well, 11 is also similar, but then here, my lord, it's a case of family pension, my lord, not compassion family pension.
Huh?
I
Just
tell you,
wait,
11.
you wait your turn, you wait your turn. Item
My
three.
lord.
May I please to the lordship, kindly this matter is pass over the timing.
Next.
Item 4.
Hey, please, your lordship. My lord, petitioner was appointed in the year 1993
Huh?
against my lord sanction vacant post following a due procedure. My lord,
Huh?
he retired from service in the year 2021. However, my lord, departments wants to bring them under NPS as their service was regularized in the year 2005. And similarly situated person being approached this honorable court, my lord. Kindly see High Court order, my lord, page 58. Petitioner is similar, but he was
Page
not
28,
58, my lord.
58, yeah, yeah.
And my lord, petitioner is similar, but he was not a party, my lord. So he filed one representation, my lord. Representation is Annexer H, page 60.
Mr. Counsel. Okay, they are disposed of in 22.
Yes, my
So you are similarly placed as these writ petitioners. So you want a similar order.
representation is pending, my lord.
Okay.
We dispose of in the same
So,
line.
okay, since the writ petitioner is similarly placed, same order,
Same. Or my
Mr. Bora,
Representation may be disposed of.
that's what I'm saying. But your writ petition was rejected. Your writ petition was rejected.
need to consider representation.
It was rejected. I'll reflect that because it was rejected.
But my lord, process is going on, my lord.
Maybe, but I have to, you see, we have got to bring out the correct facts.
Yes.
Because we have been appointed in excess of the available sanction force. That is the same. That is what these writ petitioners are here. They were appointed in excess of the sanction force. Anyway, right. Heard Miss
Yes, Bora.
S. Bora, learned counsel for the petitioner, who submits that the petitioner was initially appointed as an assistant teacher at Kandamtal ME School, Sonpur district on 22/9/1993. The petitioner retired on 2021. The respondents have brought the petitioner under the purview of the new defined contributory pension scheme, along with other similarly situated persons who had been, you are regularized when?
2005, my lord.
Who were regularized
20
after, when? Which month?
22/8/2005.
Were regularized after 1/2/2005. Comma, that is on 22/8/2005. The petitioner's counsel submits, the petitioner's counsel submits that the other similarly situated teachers had preferred WPC 3543 of 2012, praying to be brought under the purview of the Assam Service bracket pension bracket close rules 1969. Full stop. The WPC 3543 of 2012 was disposed of by an order dated 10/5/2022. With a direction being issued to the petitioners therein to make a representation before the secretary to the government of Assam in the elementary education department and in the event of the representation being filed, the secretary to the government of Assam elementary education department was to was to give meaning to the word inverted commas adjusted appearing in the fifth column of the list enclosed with the order dated 22/08/2005 and the implications thereof. Full stop. What has happened to the earlier representations? Any idea? No idea.
My representation pending, my lord.
No. What about the others in the repetition?
And process is going on, my next.
Acha.
D,
Uh-huh.
page 59.
Next para. The petitioner's counsel submits that in terms of the order, in terms of the direction passed in WPC 3543 of 2012, acha, the name of the party, huh? Abani Barwa and 44 others versus State of Assam and others, huh? Page 35. What have I said? The petitioners therein had submitted their representations and the same is still under consideration. Full stop. Next para. The petitioner's counsel submits that a representation dated
6/9/24.
6/9/24 has been submitted by the petitioner to the secretary to the government of Assam Elementary Education Department to be governed by the Assam Service Pension Rules 1969. And as the same has not been disposed of by the respondents, the secretary to the government of Assam Elementary Education Department should be directed to dispose of the petition's representation in terms of the direction passed in WPC number
3543.
3543 of
2012.
2012. Mr. P.K. Bora, learned counsel for the Elementary Education Department, submits that he has got no objection to the prayer made by the petitioner's counsel. But you have already retired, madam.
Huh?
Your case, you have already retired.
My lord,
You did not, when did you, your representation was when?
6/9/24.
6/9/24, after your retirement.
My lord, earlier also we have approaching many
Oh,
of
now you have lost. No
my
case,
lord,
madam.
many of them have retired in WBC 35.
They have retired.
Yes, madam.
Okay, right. I've heard the learned counsel for the party. It is seen that the petitioner had retired on
21/3 to 20 March 2021.
21. When?
21, my lord. 18/3/21.
It had retired in the year 18/3/21. And the petitioner, no case, madam. After 4 years, 18/3/21, and the petitioner has only now, and has only made has made a representation for being covered by the Assam Service Pension Rules 1969 by way of a representation dated
6/9/24.
6/9/24.
Last representation.
Full stop. Further, the petitioner has filed the present date petition only on 17/3/2025. You retired in 21. That is 4 years after her retirement.
My lord, I have filed earlier also. This is last representation. And
Maybe. Next, you're right. The writ petition filed by the similarly situated persons, that is WPC 3543 of 2012, had been rejected by this court-wide judgment and order dated 10/5/2022. As such, this writ petition, full stop. The reason for the rejection was, one of the reasons for the rejection was that the appointments had been made in excess of the available sanctioned vacant posts, correct?
my lord, petitioners were appointed, my lord, regularly, my lord. However,
Okay, had been rejected. No say anything. On considering the above, on considering the fact that WPC number 3543 of 2012 had been rejected, no direction can be passed by this court for making the Assam Service Pension Rules 1969 applicable to the petition. The only thing, there's nothing left, madam.
only kindly see annexure G, my lord, page 59.
Yes,
Page 59, my lord. Only consideration, my lord. Kindly see letter by the undersecretary to the director for consideration of pensionary benefit WPC.
That's right. Next.
That's why, my lord, I'm.
The entire issue regarding whether the petitioners in WPC
3543.
3543 of 2012 are to be are to be given the benefits of the Assam Service Pension Rules 1969 has been left entirely at the discretion of the state government.
But in this revision 2012, they have approached before their retirement. They have approached this.
No, but then the only thing is that if they get, then why shouldn't she get? That's the only thing. So, what do I say? It's entirely as per the discretion. Accordingly, the Secretary to the Government of Assam, Elementary Education Department, should also ensure that the decision taken with regard to the representations made by the petitioners in WPC 3543 of 2012 should also be made applicable to the petitioner herein, if the petitioner's case is found to be similar to the petitioners in WPC 3543 of 2012. Full stop. The same is also further subject to the state government taking a decision in favor of the petitioners in WPC 3543 of 2012 as per their discretion. The writ petition is accordingly disposed of. So we'll only say that no need of your representation being decided. Oh, my thing is that, pause this. Yes,
May I please, Authority? My lord, matter pertains to non-issuance of formal regularization. My lord, petitioner is all along being treated as a permanent employee, my lord. He is serving from 1994, my lord. And he is getting regular annual increment, everything, my lord. Just, my lord,
what petitioner is that?
serving since 1994, my lord.
Serving since 1994 as what?
As a, my lord, agri machinery inspector, my lord.
Huh?
Agri machinery inspector,
Agri machinery inspector. Then what else?
my lord. He was appointed in the regular pay scale, my lord. But, my lord, formal regularization order has not been issued till date, my lord. Otherwise, my lord, he is getting everything, my lord. Annual increment, everything, my lord.
So what do you want?
At this stage, notice may be issued, my lord.
For what? No, no. What is your prayer in the writ petition? What is your prayer?
Issuance of formal regularization order, my lord.
Why?
My
On
lord,
what is the basis for you asking for regularization?
my lord, he was appointed in the year 1994, my lord. At that
No, no. All these documents are for what? In support of your submissions. Show me the documents which are in your favor.
my lord, there is an order of this court also, my lord.
Let us see. Let us see. Let us see.
Page 43, my lord. Petitioner earlier approached this honorable court, my lord.
Page 43.
Page 43, my lord.
What does it say?
My lord, your lordship will relevant paragraph, my lord. Page 45, my lord.
Yes. What does it say?
Having regard to above and taking into account that the petitioners are serving on ad hoc basis since 93-94, and several proposals were started earlier for regularizing their service. The respondents are directed to take effective steps to regularize the service of the petitioner, either by completing the earlier regularization process or by conducting a fresh exercise in pursuance to the director's communication dated so and so. This order is found to be justified since similar direction.
This matter pertains to bench matter, my lord.
Just a minute. Yes. Tell me.
Necessary exercise in this regard be completed expeditiously and preferably within 6 months from the date of receipt of communication from the petitioner. Cases are disposed of accordingly with this direction. The copies of this order in the two connected cases of junior instructors of Gargaon and Sikuna ITI, as well as the copy of the communication dated so and so.
But your name is not here in this writ petition, in these cases.
Name is there, my lord.
Where?
Page 41, my lord.
What is your name? Nurul Haq.
Nurul Haq, my lord. There are 3, 4 writ petition, all were clapped, my lord. Otherwise, it may be bench 3 matter, my lord. Looks like
What about this page 39?
30, 39. My lord, 39, type copy 37, my lord. It was the steps, my lord, during the pendency of those writ petition, my lord. That steps was taken, my lord, by the respondent authority. Then this court, on this honorable court, disposed of the writ petition, directing the authorities to complete the process either by way of this communication or by issuing a exercising fresh, by taking fresh exercise, my lord. My lord, otherwise.
So this is what bench you said? Is bench 3 matter?
I'm not sure, my lord. Otherwise, ITI is there, my lord. So it may be bench 2 also, a educational institution. My lord, at this stage, notice may be issued, my lord.
No, let it go to the authorities. ITI. Let it go to the registry. Let him file before the appropriate bench. Right. Mr. G. Pegu submits that the matter pertains to the pertains to bench 3. Registry to verify and leave the same before the appropriate bench. Huh? Give your upon them, man.
I think what.
Item 1. Yes.
My lord, some certain instruction has been received, my lord.
Copy to him also. Oh, you have made only one, as usual. Should let him see it. Let him see it first.
My lord may take this one. My lord, as per the instruction,
Page, the third page, your lordship. The third page. Serial number 1, Avinash Das.
Ah.
As per certificate submitted by the candidate, the degree not obtained from the AICTE recognized institute, we have already preferred our averments in the writ petition pursuant to that, because we're aware the deficiency that the government has thought of. There are already averments in the petition. Accordingly, we have also a Supreme Court judgment that states that institutions other than universities do not require AICTE approvals.
Huh?
AICTE only modulates the courses. The university does not need to be accredited to the AICTE. It is the UGC regulation which will hold force. We have made averments to that effect. If the respondents can file a short affidavit in the matter, we
File
already
an
have
affidavit.
Yes, my lord,
we already have a
Credibility
reply
requirement.
in the petition itself.
I need the citation.
Yes. I'll have a copy.
No, anyway,
Yes.
let him file affidavit.
Yes.
Wait, how much time?
2 weeks, my lord.
2 weeks. Mr. S. Das, learned counsel, submits that he has received instructions that the petitioner has not been included in the
Yes.
list
Yes.
of part-time / guest lecturers. Is it?
Yes, my lord.
Yes.
3F, under 3F.
Under the list made under section 3F of the APSC Limitation of Functions Regulations 1951. Due to the fact that the mechanical engineering degree obtained by the petitioner has not been obtained from the from an AICTE recognized institute.
The BTech.
Huh?
The BTech.
Undergraduate.
The BTech. from
B.Tech.
Info University. Yes.
Mechanical engineering, I said.
Yes.
No, that's all.
Yeah.
Issue notice returnable in 2 weeks. Mr. S. Das submits that he will file affidavit within 2 weeks on the basis of the instructions received by him.
Respondent number 3,
Miss
K. Barpuzai on behalf of H. Omar.
K. Barpujari appears on behalf of Mr.
H. Omar,
H. Amal and counsel for the
UGC.
UGC. The respondent UGC should also file affidavit if required within 2 weeks.
My lord, regarding respondent 4, my lord, I think notice will go.
Petitioner to take.
Yes, he
What?
was already present on the earlier occasion.
Is it?
Yes, KP Pathak was
KC Pathak,
present.
Okay. So, Mr.
I'll inform my lord.
KP Pathak, counsel for the AI, for the respondent number 4 shall also file affidavit within 2 weeks.
Yes.
List the matter. When
Pray for a date, your lordship, because
Bibhuti should give.
when 9
9 April.
9
10th, my lord.
10. You file it, but
Yes, sir.
I'm grateful, your lordship.
My lord.
Item 6.
10th April.
Yes, yes. This is regarding illegal deduction of on the DCI.
Item
Item 6 was. Legal deduction, less amount of pay salary has been given.
Okay, we'll issue notice for the heard Mr. S. Bora, learned counsel for the petitioner, who submits that the petitioner retired from service on
31/7/2017.
31/7/2017.
31/5/2017.
31/5/2017. The petitioner's grievance is that there has been an illegal deduction of rupees 1,54,104 from the DCRG payable to the petitioner. So subsequently, there has been an improper monthly fixation of pension at rupees 37,901 instead of 39,520. So thirdly, no pension has been released from April 2024 to May 2024. What time scale of pay? What are you talking about time scale of pay?
There should have been a time scale of pay because 24 years he had worked, but no.
Where is the rules? Show me. Where are the rules provide for time scale of pay? Show me.
Matlab,
Show me the rules.
right now I don't have it, my lord. In the whole entire career about 24 years.
You see, Mr. Counsel,
I will- I will
you
let
do understand the meaning of time scale of pay?
Every 10 years, there should have been a review of this particular.
Where is that?
Matlab, let it be there, but I will not record it, my lord.
No, I'll record that you do not have any supporting document to make a submission.
My lord, let that pair be dropped, my lord.
Huh?
Let that pair be dropped.
You should. Well, this is of no use. Right, Mr. S. Bora submits that. The petitioner will not be pressing his prayer number 4. Prayer number 4.
6 also there.
No, 4 is
No,
there.
not 4.
Not 4, not 4. Number 6.
Six. Not 4.
Number 6. For granting time scale of pay to the petitioner with retrospective effect. Issue notice returnable in 4 weeks. Mr.
A.R. Tawhidar.
A.R. Tawildar accepts notice on behalf of
1, 2, and 3.
1, 2, and 3. Mr. S.K. Medi,
5 and 6.
5 and 6. Who else? 3. Who is for 3?
3, sorry, 3 and 1, 2, and 3, Lord.
You are for 1, 2, and 3.
Lordship.
Who is for 4?
4 I will take steps.
Huh?
4 I will take steps.
Okay. Petitioner will take steps for service of notice. What about 7?
7.
Ms. R.M. Barwa appears for respondent number 7. Petitioner takes steps for service of notice upon the respondent number 4 by registered post with AD within
Within a week.
a week.
Item 7.
Stipendary teacher praying for old pension, my lord, they given the new pension, my lord.
How
Your
much
lordship
days delay?
issue Notice, my lord.
Huh?
Your lordship issue notice, similar order, my lord, similar case.
When did you retire?
Retired on 31st, 31st January 2025.
31st January.
That is a settled position law where any arbitrary condition imposed that anytime they can oppose before down what Supreme Court says.
Supreme Court says,
That it arbitrary clause is imposed because there
but that
there
is
is no
also,
bargain- they
that
have
is,
no
al-
bargaining power,
that is also subject to latches and delay.
my lord.
Supposing there's an arbitrary order passed today,
My
can you come after 20 years?
Cannot. Your lord.
The petitioner heard Mr.
Only my lord.
N. Borala, counsel for the petitioner who submits. The petitioner retired from service on 31/1/2025 and claims the benefits under the Assam Service Pension Rules 1969. However, the respondents are planning to give the benefits under the NPS to the petition,
A stipendary teacher. They are initially appointed
as he was a stipendary teacher.
Initially.
As he was, that's what I said, as he was a stipendary.
Madam, newly accommodated as teacher, madam, page 50, madam.
That was challenge before lord.
Anyway, issue notice, returnable in 4 weeks. Miss S. Tutti accept notice on behalf of respondents number 1 to 5.
Fine.
While Miss R. M. Barrow accept notice on behalf of respondent number 6. This is the matter after 4 weeks.
Along with this, well, matter will be listed along with
Along with that, what is that case number?
WPC number.
WPC number 1434 of 25.
Item 8.
Yeah, my friend, Mr. Prakash is in another court, my lord, so timely. After some time.
Okay, after some time.
Item 9.
Okay, right. Heard Mr. M. Khan, learned counsel for the petitioner who submits that though the petitioner's father died in 1910-2016, the petitioner has not been paid family pension or the GPF. Issue notice returnable in 4 weeks. Miss S. Tutia accepts notice on behalf of
No, 1, 5 and 8.
1, 5 and 8.
1, 5 and 7, madam.
1, 5 and 7. While Miss R. M. Barrow accepts notice on behalf of
3 and 8.
3 and 8. Miss full stop. Mr. G. Pegu accepts notice on behalf of
2 and 6.
2 and 6. That's all. This is the matter after 4 weeks.
Item 10.
Make please, your lordship. Lordship, here petitioners are the local public and guardians of the students, my lord. Two students are reading in Boralga High School. My lord, the school, by the impugned order, my lord, page 56, marched with the
Amalgamated or amalgamated?
march.
What is the difference between amalgamated and merged?
Same, my lord, it is marched it is marched, my lord, it is amalgam, same meaning, my lord. Merger with another school.
What is the provision for amalgamation or merger?
Merger, my lord, if there is, my lord, there is a provision of section 12.
Where is that?
That is space Page 119 of 17 Act.
Huh? There is no 100. I've got only up till page 67.
No, my lord, Act of this.
Oh, which book? Show me the book.
This Education Manual. 2017 Act,
Page 100 and
119, section 12.
section 12. Yes.
12.
So it says amalgamation / merger.
Merger.
So both of us are correct.
So here it says My lord, section 12(1). In appropriate cases, if there is already an existing educational institution nearby and the enrollment of the student do not justify for more than one institution in the same locality, or there are other sufficient reasons so to do, the state government in the public interest and for reasons to be recorded in writing may, or for transfer or shifting of the institution and incumbents of the institution from one place to
So
another,
it can be done.
can be done, but reason should be there. But case 56, no reason is there. Our case is that the distance between this school and the merger school is about 7 kilometers. That cannot be. So my
Why, what does the rule say?
rule
Does
says
the acts,
access if it is within 5.
where, which
They-
state?
Even my lord, if it is base school, it can be merged with only base school. And
Let us see which.
my lord, that is, my lord, definition of base school, page 102, 102. Now, my lord,
Just 100.
there is.
Base school means either. No, this section 12 doesn't talk about base school.
But impugned order says base school. It is not basic school. Our school is basic school. Our own school is basic school. Now, my lord, if kindly come to impugned order. Page 56. My lord. Page 56.
Yes.
In persons of government order instruction issued in file number so and so dated so and so, the director of secondary education Assam is pleased to issue the order of merger of.
Okay, we'll issue notice. Let's. Oh, you have to what?
I'll issue notice, your lordship. This is.
When was this order? Oh, 1 year ago. All right. Heard Mr. M.R. Kandakar, learned counsel for the petitioners who submits that the merger of the petitioner school, that is what?
Borar Alga High School.
Barar Alga High School with Hatsingi Mari Senior Secondary School as base school should be set while the impugned order dated 2/3/2024 issued by the Director of Secondary Education should be set aside. So one of the reasons being that the distance between the two merged schools should not be beyond
5 kilometers in case of high school, my lord. My lord, page 102 is there. Our school is high school. In case of high school, my lord, distance should not be beyond 5 kilometers.
beyond 5 kilometers. As the petitioner school is a high school, while the other school is a
Basic school.
About 7 kilometers.
no. What is ME school? What? The
Basic
other-
school.
This is the highest.
both are high schools.
No, I have marked with the senior secondary school.
Okay, so you are a high school, the
I'm
other
high
is, while the other school is a senior secondary school. So senior secondary school 103. Yes, higher secondary school 7 kilometers.
But I am not higher secondary, I am high school.
You might not be, but the other one, the
Other
base
one
school
is
is
basic school is-
the base school is the same thing.
But it is not my basic school, I am showing my order. My lord. They have wrongly written basic school. My lord, page, kindly page 43. Page 43, that is our provincialization order. My lord, serial number 1. By this order or services.
So,
The Boraranga High Madrasa is the identified serial number 1, my lord, page 43. The Boraranga High Madrasa is identified as base school for this school.
Huh?
So our school, own school is base school.
your school was base school in 21.
21.
In 24, you are no more the base school.
They cannot, director cannot say I am the base school. I have base school my own because there is no other school within the 5 kilometers within the high school radius. So our own school is the base.
Have you submitted any representation?
Yes, my lord, I have.
Well-
There is a OM, my lord.
Acha, full stop. Secondly, the petitioner's case is that the Briar Alga High Madrasa already having been identified as a base school by order dated 4/1/2021 passed by the Director Secondary Education, comma. The
Amalgamation, replacement committee, no?
subsequent identification of the Hatsingi Mari Senior Secondary School as base school by the impugned order dated 2/3/2024. Could not have been done. That's your case.
Another is, my lord, there is no reason as rule says section.
First of further, no reason is given in the-
Section 12.
in the merger order, in the impugned order, giving reasons for the merger of the two schools, which is arbitrary. In terms of
Section 12
section 12
of the Assam Education 17 Act.
section 12 of the
Assam Education.
okay, that is at okay, that 2017. Good stuff. Next para. Okay, issue notice returnable in 4 weeks. Miss P. Das accepts notice on behalf of
Secondary education. Respondent number 1, 2, and 4.
1, 2, and 4. While anybody else? Nobody else.
Commissioner,
While Mr. G. Pegu accepts notice on behalf of,
respondent.
that's point number 3. Section 2, bracket D of the 2017 Act states as follows, huh? Wait, 2, what else? What are the sections?
12, my lord.
No, one is section 2D, then comma section 12, let me see. Section 12, huh? Section 12, and section 12 of the, so, states as follows. That's all.
Yes, sir.
List the matter after 4 weeks.
11.
Please, your lordship.
Notice issue.
Yes, what do you want?
Page 43, my lord.
Yes, your son died when?
My lord, he died in 1317, my lord.
So compassionate family pension is out.
No, he'll getting family pension. In fact, he'll be getting family pension. And that was provided, provisional pension was provided. Page 43. Thereafter, in May 2023, it was stopped. Then I inquired, then they said that you have been paid the NPS amount wrongly. So you deposit it back. I deposited it back. Now they are saying because of this notification of 27 September, before this notification, I deposited the money back. Page 50, because of this notification.
Which page?
Page 50. I deposited the money before that. Now, because of this notification dated 27 September 2024, they are saying, no, you cannot, you couldn't have refunded the back and you are not entitled to other things, benefits. And that impugned order has been passed.
So you're claiming family pension under the 69 rules,
Yes, madam.
and you had been given the money under the NPS and you gave it back.
No, I was initially provided a provisional pension. That even I was also provided this money under the NPS, which I returned back.
When were you given the NPS money?
NPS money was given in 17 only.
2017.
17.
When did you return the money?
Returned the money when I was asked to return the money in
When?
23. But before this notification. They realized their mistake and they said, you refund the money. I refunded the money.
Is it, did they ask you to refund it by way of some document?
Yes, madam. Yes,
notification.
chalan, madam. Chalans are there.
No, challan is made by you.
My lord.
I am asking, was there any written letter?
No, my lord, they
given
said
to
you
you?
deposit the money because they realized their mistake, my lord, so they didn't want any communication. I
Because
gave a-
challan can be, if I want, I can make challan also. It will be accepted.
That is true, my lord, that is true. But
That,
not-
that doesn't prove anything.
But then I have, well, this is a beneficial legislation ultimately, madam. I have to given that option, my lord, which I want to choose, my lord. They gave both the money to me, my lord. The provisional pension was also paid to me.
Okay, right. Heard Mr. M. Datta, learned counsel for the petitioner who submits that the petitioner's son died, expired on 1/3
17, my lord.
1/3/17. Thereafter, the petitioner, who is the mother,
Yes.
was given provisional pension in terms of the Assam Service Pension Rule 1969.
My
Is
lord,
it?
my lord.
She was also given all the benefits under the new pension scheme. However, she, on being informed by the respondents, the petitioner, on being verbally informed by the respondent, the petitioner returned the amount that she had received under the NPS, so as to enable the respondents to give the benefits under the Assam Service Pension Rules 1969. So he submits that though the benefits under the NPS amounting to rupees
My lord,
144,591.
No, my lord, it's 4 lakhs, 4,965.
4 lakhs,
4,965.
you got,
404,965.
had been returned to the respondents on,
My lord, by challans, my lord, dated, my lord,
had been returned by challans
my
in
lord,
the year,
5/1/2024, my lord.
in the year 2024.
5/1/24.
2024. The family pension under the Assam Service Pension Rules 1969 has not been paid to the petition. Issue notice returnable in 4 weeks, Mr.
If you can, my lord.
For
Lord, this one number. My lord, 6, my lord. What has happened is, my lord, in the cost list, it's reflected as elementary, but in the cost title, it's reflected as secondary. My lord.
So you're for
Yeah.
6.
Time for 6, my lord.
6. Mr. G. Pegu for 3. Miss R. M. Barwa for 2.
My lord, the pendency may not be barred, my lord, for this.
Next.
Petitioner before she was a regular teacher, my lord. She was retired on 31/12/2024, my lord. She's challenged the appointed as a tutor, my lord, and given that new pension scheme, my lord. Because of that, there earlier, my lord, in 2008,
What? You retired when?
retired on 31/12/2024.
31/12/24.
December.
Then?
What problem is that, my lord, they give it the treated me as a tutor because of there is a specific direction before this honorable court. There is a order, my lord. And I was a regular teacher, my lord. After my salary was stopped in 2003. And because of that, alleging that I was terminated in the year of 1992. And she came before the honorable court and saying that at the time he challenged the termination as well order that was set aside by the honorable. Your lordship, go to the annexer, my lord, annexer 6, page 75, my lord. There is a specific direction, page 75, my lord. And turn into page 76, my lord, last para, my lord. Last para, my lord. Your lordship got it, my lord. Page 76, my lord.
How can you now turn around and say otherwise?
Otherwise, page 76, my lord. Because of that, there is a, please may kindly see last paragraph, 76. This order has been passed on 13/8/2010, my lord. The last paragraph, my lord, the pair made this writ petition is to allow the petitioner to draw salary with effect from September 2007 onwards. Similar nature case came up consideration before the Honorable Division Bench so and so. In case the Honorable Division Bench directed respondent to release salary of the petitioner, which have been withheld October 2007, following
No,
order.
these are all past history, all finished.
But
Nothing survives now.
no, there is a, therefore they pay their salary regularly, my lord.
Maybe,
And thereafter, my lord, the authority, my lord, please may kindly see, turn into page, thereafter contempt proceeding was drawn up, my lord, page in page 80, my lord. The 80. One undertaking, Mr. D. Soikar, learned additional advocate general Assami contempt petition is closed. Time is granted for compliance order report in the present commission as secretary in the department, my lord. And thereafter, my lord, they issued a by supernumerary post, my lord. Page 81, my lord. They given salary 1/10/2003 to 28/2014. And Honorable Court specifically directed that the salary will be paid regularly. They did not, but they did not file any appeal or review. And thereafter, they issued a, my lord, order as a tutor, my lord. And now he's retired, says that is the regular teacher, my lord. She cannot be challenged before a lordship, my lord. So at this stage, notice may go, my lord. Similar issue was, my lord, in Tutor is concerned, my lord. Honorable Court passed the order, and thereafter the government challenged the before on again is that he has appointed as a tutor, and Honorable Division Bench set aside that a tutor order.
If, notice may go, my lord, and we'll file appropriate affidavit of it.
Heard Mr. N. Bora, learned counsel for the petitioner. The petitioner has paid for setting aside and quashing the impugned order dated 30/01/2021, issued by the Director of Elementary Education, by which the petitioner has been working as a tutor
My lord.
from 30/01/2021. This is retirement on 31/12/2024.
My lord.
He has also paid for release of salary from 1/10 to, no, that has already been paid. 1/10/2003 to 14 has already been paid.
My lord, not as a, my lord, full scale, my lord. They receiving full scale, they given only 1,800. I am for them.
How can you go back? Oh, no, right.
But
I
that
don't think you have-
direction was not reviewed, that is the finality, my
I don't think you have, but anyway, right. Issue notice returnable in 6 weeks. Mr. A. Fukan accepts notice on behalf of
Respondent 1 to 5.
1 to 5, while Mr. S. K. Medi,
7.
one number 7, Mr. G. Pegu for 1 number, Miss. Adam Barofa. This is the matter after 6 weeks.
I did 40.
Maksud.
This matter is pertaining to suspension.
Huh?
Suspension matter, Lordship. Look, the petitioner was suspended, Lordship. Page 21 is the order of suspension.
So you're still under suspension.
My lord, is still under suspension.
There has been a review of the suspension.
No review.
Lordship, for that, your lordship, I need to take instruction.
Is there any criminal proceedings against you?
Yes, criminal proceeding is continued.
What is the stage of the criminal proceeding?
Evidence is taken.
Evidence stage. POXO.
Foxo is there.
Because of that
Huh?
reason, might be he was not, your lordship.
No, no.
considered.
That cannot be a reason by itself. You see, you have to give that is the reason, no doubt. But for extension of the suspension period, review has to take place. If it has taken place, well and good. If it has not, then you have to reinstate. So just ensure where you just have to see whether review has taken place or not. And what about the DP, departmental proceeding?
Well, that departmental proceeding, hearing to the petitioner has already been concluded, but
Has been
the lordship, the hearing part has already been concluded.
no final
But
decision.
no final decision, no inquiry report.
The inquiry report has not been furnished to you.
No.
Right. Heard Mr.
M. Khan.
M. Khan, learned counsel for the petitioner who submits that the petitioner was suspended on 20/05/23 pending departmental proceedings. Is it? Or was it deemed suspension? Was
No,
it due to a criminal
no,
case?
No, before that lordship, you are suspended. After
Okay, pending
there is-
departmental proceeding. Good stuff. The criminal case under section 6, is it?
six,
Of the POXO Act was also registered against the petitioner. The petitioner's grievance is that the petitioner's suspension has not been lifted despite no review having been undertaken by the respondent authorities with regard to a suspension order. Good stuff. The petitioner's counsel submits that though the departmental proceeding has been submits that inquiry report has been made.
no
Is it?
inquiry report.
Submits that though the proceedings of the inquiry of the department proceedings have been completed to a certain extent, the inquiry report has not been furnished to the petitioner till date. He also submits that the criminal case is at the stage of recording of evidence. List the matter after when?
2 weeks.
List the matter on 9th. To enable Ms. P. Das to obtain instructions as to whether there has been a review of the petitioner suspension order. Suspension, huh? Review of the petitioner suspension.
I did 14.
Deeply offense. Make major losses.
Item
14, my lord. I have come earlier before my lord. Lordship, in this case, my lord, petitioner was promoted as a deputy inspector of school on 1/2/2025. Then before that, I have filed one petition, that is, my lord, that is for 17/2/2005, my lord, to forgo my promotion because of his ill health.
are you allowed to forego your promotion?
No, because of my health and
No, I understand the reason that you're saying
Yes,
that because of your health,
my next, my lord, one.
because of your health, you want
Not
to
only
forego.
health, my lord, and mental case.
Okay, for whatever reason,
Yes,
I'm not
yes.
on that. Can you forego your promotion? What does the law say? Can a person forego his promotion?
But they have already been forgot, my lord, that is annexure 11. I have shown, kindly peruse the annexure 11, 54.
Page
There are
54.
some 54 page. One, Rana Sharma, forgo earlier promotion. They know, my lord. whether they can
Where,
forego
page,
page 54,
before, yeah,
2, 3, and my lord 5.
huh,
Your promotion has been forgot earlier, my lord. Then why not me, my lord? Because I'm suffering, my lord.
yes.
And that too, my lord, I will be retired within a period
If
of
you
9
see,
months is there.
you see, the petitioner wants to forego the promotion, then you can transfer her without promotion. Yeah. She doesn't want to be promoted. You can transfer her without promotion.
Lordship, they were not executed the order passed by your lordships, my lord. 2 points, yes, my lord. Lordship kindly page 30. Your lordship stated that the petitioner council submitted the promotion order requests the petitioner to move an office which is 340 kilometers away. The petitioner is suffering from various medical ailments. His elder daughter is going to be appear in the HHLC examination, which already been started. Further, the petitioner is going to retire within less than 1 year. Then your lordship turned the order, my lord. In this order, they have stated about the promotion. They will not allow to forego the promotion. And my lord, HSL examination, that is para 5. Since it is completed 3/3/2025, so he should go to that place, which is 350 kilometers away from the
Which page are you reading? Page 34.
order is 34. It was not executed, which your lordship has passed this order, my lord. And it is not stated that I have approached this honorable court. Just it is stated that they make they made a hearing. But it is not stated that as per court order, they made a hearing, my lord.
No, you see, the issue is this, whether she can she can forego her promotion. If she can forego, she says let her forego.
Yes, my lord.
I go,
Let
let her go.
no, so she won't be promoted. But then that does not bar them from transferring
No,
you.
my lord, there is a notification, man. I have already applied, but it is not with me. And Kostov also, he also, I asked Kostov, he will provide me. My lord. There is a notification that is 2002. It is not with me. Of course.
Stating what? Stating what?
That within a period of 2 years, the petitioner, the person who will going to be retired within a period of 2 years, generally they will not transfer.
Generally, they
Because
are
of-
not.
Yeah, because of difficulties of pension and everything, madam.
But that is not enforceable. A guideline is not enforceable in law.
And there are managed in central office also, there are guidelines like that.
Yes.
And lordship order is not complying. It was
No, no.
not executed. That is regarding my lord, I mean to say retired and I am suffering. The person who is suffering from he is suffering the ailment, he's a ailment, my lord. And that too, he has been transferred to 350 away from his own place.
Okay, so
Kindly consider this.
so
matter.
yeah, so it appears that the persons have been allowed to forego their transfer, their promotion. So we'll say that since she has foregone her transfer, but that has to be accepted by the authorities. I think I don't know. Hence, what is the provision? Is there
Lordship,
any?
kindly issue notice, let them bring instruction why your lordship order was not executed.
No, that's not the issue.
Yeah, Madam, kindly peruse.
Madam, please answer my
Madam,
question.
kindly peruse the.
No. Please answer my question. Can a person forego her promotion, his or her promotion order? Can you say that no, I will not take it? I just wanted to know.
Yeah, because there is a reason, my lord. There is a reason. Because he is suffering, he is away from 350 kilo, and that too, he is going to retire. He is 8 months is going on to be retired, my lord. Your lordship, kindly look into that.
No, that is a different thing. I am looking at the issue, the law point.
And I have mentioned the repetition.
I know
They
what
have
you want.
lordship.
You want notice. You want stay.
In this
That's
case,
all.
yes. The order may kindly be stayed. Yes.
Regarding forego, my lord,
Only that part. Can it? Look, she wants to forego. You take a decision.
after that we
Yes.
can also,
Naturally, that is entirely up to you. So we will say that till you take a decision with regard to her foregoing her thing, she should not be touched.
In my life also, I have been invited to be a judge in Guwahati High Court twice, my lord. I refused. That is the point.
That is not promotion.
Of course, not promotion.
That is not
Like
promotion.
that, like that.
Ah. Yeah, there is no high court service where you can.
I know.
ah.
Short time may be granted, being instructed.
In
Huh?
the meantime, my lord,
Short
the
time
order
may be
dated.
Yes, for short time, no.
After
We can dispose of this writ petition.
Well,
We'll say that you take a decision because she says that she wants to forego.
Yes.
So so once it is foregone, then there's no question of transferring her. That goes for a sick.
that
So you have got to take a decision
regarding,
whether you accept her stand that she wants to forego.
regarding,
Where is your letter
Yes.
to the authorities saying that you want to forego the transfer?
Yes, that
Where?
is one. Lordship kindly peruse the
Page?
page 26.
Interesting.
And that letter was examined and passed an order 6/3/2025. And they never written like that as
Ah.
per coach order.
So she wants to forego, take a decision on this.
Yes.
You know.
regarding other part, that may be kept open, man.
No, so
Only-
once you decide, if you decide that she has to forego, she can forego,
Yes.
then that order becomes infructuous.
Only
Actually, because she will not be
but
promoted.
without promotion, we can do.
Huh?
Without her promoting to that post in other purpose, my lord, we can transfer her.
Actually, everybody can be transferred. There's no doubt about it. Subject to what Miss Devi will bring out next time.
And Lordship, it's very strange because after passing the order, my lord, I have submitted documents and everything, and they have never stated in their government order that as per court order that it is made a hearing, my lord. They never said like this because if they would mention about the court order, they would have been considered the other things also, my lord. Very unfortunate, my lord. Because after passing the order, they should write in the letter that as per court order, he is invited, petitioner is invited for hearing. It is not
Okay,
written
right.
like that, madam.
Right, Miss K. Devi, land counsel for the petition, who submits that the impugned order dated 6/3/2025, rejecting the petitioner's representation dated 4/2/25. No, rejecting the petitioner's representation dated
Retention dated 4/2/2025.
praying for exemption from promotion. To the post of Deputy Inspector of School, Demaji, should be set aside. The petitioner's counsel submits that when serial number 2, 3, and 5 of the order dated 13/3/25, bracket annexure 11, comma page 54, bracket close, of the writ petition shows that the said persons, that is Rana Sarma, Ezra Rasuna Lal Sim, and Lisa Bella W. Momin, have been allowed to forego their earlier promotion, comma. There was no reason for the respondents not to allow the petitioner to forego his promotion order, comma, which would entail that the transfer order which no, no. What have I said? No, cut that, which would entail, cut that. Just read before that. Full stop. Where is this 4-2? 4-2-25, where is this? Madam?
Yes,
And except five, page 20, page 20,
page 20.
Page 20.
28,
28. But page 20,
and except five,
42, yes, 42 nahi?
4 to 25.
Yes, madam, page 28.
So already that decision has been taken. They have rejected your prayer to forego the promotion.
No, order has been passed on, my lord.
6-3.
Yeah, 1/2/2025 to
Wow.
promote me.
No,
Exactly.
no.
Yes.
So 1-2, then after you made an application
Yes, my lord.
to forego the promotion.
Promotion.
So they have
Because
taken,
did not take any decision that.
no, they have
that
taken the
is why-
decision.
No,
They've taken-
that is why I approached this honorable court.
So this has been challenged now.
Yes.
Yes, so can someone be stopped from being promoted? I mean, she doesn't want to be promoted.
Yes.
Can you say that she
You
has to
must
be
have-
promoted?
That cannot null regard.
And no, and you have to show also whether you can reject a promotion order. As per law.
That point, my lord, I have to take instruction
Okay,
on my
right.
client.
Issue notice
Yes, my lord.
returnable in. Yes, how much time?
Maybe after being-
Yes, how much time?
2 weeks now.
Returnable in 2 weeks.
Above.
Mr. P.K. Bora accepts notice on behalf of respondents number,
Both the respondents, two respondents.
both the respondents. He shall obtain instructions as to the provision of law under which a person as to whether the rejection of a promotion order by an officer can be rejected by the authority.
They can, because I have annexed that annexer, no? They can.
The law, I want the law.
Hello.
List the matter.
Relating to that also, my lord,
List the matter.
kindly,
List the matter on eight.
it.
Eight April.
In addition to that, you also kindly inserted that during the time of 9 months, whether the petitioner can transfer to the some other place.
That is you have to show.
Okay.
God bless, man.
Notification
Till the next date.
Yeah, oh, yes, man. Please. So, train one missile. Monopoly do you know? I'm not keeping well today, my lord.
You till the next date,
6/3/25.
the
3.
impugn order dated 6/3/2025 issued by the respondent number 1 shall not be acted upon.
Only flies.
So let's see, then Bihu will be near also.
Meet with the
Item?
Lordship.
Yes, madam.
Lordship, the petitioners are aggrieved by the decision of the Executive Council.
Page?
Page number, Lordship, kindly come to page number 24, Lordship.
Yes.
Lordship, this is the 335th meeting of the Executive Council of
This is the resolution.
Yes, Lord, enhancing the get pay of the petitioners.
I don't want that.
Lordship, come to
I
the,
want the other one, the impugn order.
then Lordship, kindly come to page number 35, Lordship. By this notification, the decision of the 350 executive meeting that has been resigned.
So
Lordship.
the enhancement of the pay has been rescinded,
Yes, Lordship.
right? Heard, Miss?
M. Nirola, Lordship.
Then counsel for the petitioner who submits that the impugn notification dated 7/7/2023 issued by the Registrar Debrugar University rescinding the enhancement of the pay given to the petitioner should be set aside. Petitioners, issue notice returnable in 4 weeks. Mr.
Hardeka on behalf of Mr. R. Majumdar.
Ardeka on behalf of Mr.
R. Majumdar.
R. Mazumdar accepts notice on behalf of
All yes.
all the respondents. This is a matter of the 4 weeks to enable the respondents to file their affidavit.
Much.
Item 60.
Not basically, this case is covered by a judgment passed by this honorable court below. Lord, we are seeking the condonation of the upper age limit basing on a not.
Advertisement is of which date?
My lord,
Advertisement
advertisement is, my lord.
21, 25.
24.
Huh? Advertisement is of which date? Which
Yes,
year?
yes, my lord. It is on 14th of February 2025, my lord. My lord, first one is 8/01/2025, my lord. And the date of application, my lord, has been accepted from the, my lord, 3rd of March 2025, and it will continue till 8th of April 2025, my lord.
From 3rd to 8th of April.
My lord.
So you want relaxation?
Relaxation, my lord, they can or they can reject also, that power they have, but our applications, they should.
In terms of what?
Yes, my lord, the order, if, my lord, that notification is very difficult to find out, but my lord, if it is quoted in the order of this honorable court, my lord may be pleased to find at page 30, my lord, paragraph 27. Para 27 to, my lord, clause 3 clauses are there.
Yes.
Lordship, if your Lordship sees the application which they're talking about, there
Where's
is no,
the application page?
my lord, page from page 34
34.
onwards. It goes up till, my lord, page 37, 30, sorry, my lord, 39. My lord, in these applications, if your Lordship sees, my lord, there is no, my lord, seal signature, whether he has actually furnished. That
Lord-
also has to be a certain, my
My
lord.
lord, we have,
Should
by,
come with
by,
clean
by,
as well,
by
otherwise.
registered post, we have submitted, my lord, it has already been delivered, my lord.
Huh?
By registered post. we
Where is
have-
the registered post?
My lord, those,
Receipt.
that document, my lord, but I have taken the instruction from the petitioner.
No, not annexed.
My lord, if required, my lord, we will file a press, my lord, within 2-3 days, my lord. But my lord, it is an admitted that they have filed it through registered post, my lord.
You file a fresh representation to them. Let me
Fine.
decide it.
My
What does it matter?
Let them file a presentation, my lord.
my lord, we have that, my lord, those.
You file a fresh representation to them. You give it by hand.
My lord.
My lord.
Heard Mr. A.R. Bhuyan, learned counsel for the petition. Petitioners who submits that the petitioners are TET qualified unemployed youth. Aspiring to. Aspiring for the post of teacher. Which are to be filled up in terms of advertisement A and B, it is here. A and B, So the petitioner's grievance is that the petitioners have all crossed the
Upper age.
upper age limit required of candidates. What is the upper age limit?
40 is the upper age limit as per the advertisement.
He submits that the petition, that though the petitioners have submitted representations to the
Secretary, Government of Assam Education, Miller.
where is that? Page 30 does not talk about this.
Hello?
Maybe page 28.
No, Milord, page 30 is paragraph 27, Milord. Paragraph 2, Milord, is clear. In this rule, head of department means the authority who is declared to be the head of the department for the purpose of the FR and of the subsidiary supplementary made.
But
by
this is only for government servants.
No, no,
not
Milord.
for you.
No, Milord. This rule is for Milord 1951 for Milord. Out service employees also, Milord. Those who are not in service, Milord. That has been distinction made out in the judgment, Milord. My lordship has also passed an order, Milord, few years back, Milord. Similarly.
Yeah, what have I said? For to the concerned authorities for relaxing their overage. No, for relaxation of the age limit. No decision has been taken by the authorities. He submits that in terms of the government notification number AAP 34/50/27 dated 3/5/1951. In relation to the handbook of general circulars of government of Mizoram, Assam,
Government of Assam.
bracket blue book, bracket close, come on. The relaxation of the age limit of candidates, class of candidates can be done by the appointing authority. Or the head of the department. Or the Public Service Commission where the recruitment is to be done by the public service. He submits that. A direction may be issued to the authorities to take a decision on the petitioner's application for age relaxation. Next, Mr. A. Fugan, learned counsel for the
Elementary education.
elementary education submits that he has got no objection. But
My lord, and plus, my lord, that part can reflect, my lord, there's no representation as such, my lord.
submits that he has got no objection to the petitioner's application. However, as there is nothing to show that the petitioner's application had been submitted to the concerned authorities, there is nothing to decide by the authority. However, if the petitioner submits a fresh representation, the same will be decided by the authority.
Individual will submit.
Huh?
Individual.
Next para. In view of the submissions made by the council for the parties, comma. This court is of the view that if the petitioners make an application, make a representation for relaxation of their upper age limit to enable them to participate in the selection process in terms of advertisement A and advertisement B. No, in persons to advertisement A and advertisement B. comma. The concerned respondent should, the concerned head of the department should take a decision on the said representation within a period of 1 week from the date of receipt of the representation. So, sir, the petitioners are accordingly given the liberty to submit their their representations for relaxation of the upper age limit within a period of 1 week from today.
3 days, my lord.
3 days from today, along with a copy of the summary. And a copy of the
Judgment and order.
that's all. And the don't say any other.
My lord,
Petitioners accordingly disposed.
But the authorities will pass individual speaking orders, me.
Naturally,
My lord, that direction.
the decision of the authority, or concerned authority should be communicated to the petitioner thereafter. If,
Whether to
by
reject or whether to-
WhatsApp or by whatsoever means possible,
Exactly.
including WhatsApp.
Item
Highly
17.
obliged. Within a week, my lord.
Let them do it. We have said that it should be decided.
No, my lord, his submission has been recorded, my lord, but the direction. for-
Within a week of the decision, from the date of the decision taken.
My lord, that decision, if they do not take before 4th of April, then we will, my lord, out of the selection procedure. That's my concern. That's
I
why.
said, I've already given the time limit. What more do you?
Fine.
So I've given time limit for deciding, time limit for giving, what else?
No, my lord, only for deciding the time limit.
That will be considered, my lord, that will be considered.
Time limit I've given for deciding. I've
Fine.
even given time limit for communicating the decision. to
No,
them.
my lord,
Correctly.
obliged, highly obliged.
Item?
May it please your worship. So there is some defect in the petition, therefore I want to withdraw it and highly defend. Affidavit paragraphs are not entered.
Are you sure?
Okay.
64 marks each? 64 marks.
Yes, I am entitled for 67 marks.
You are entitled to 67. That's what you say.
And if I get that mark, then I will have been selected. So this is the case, but since there is some defect, I may be allowed to withdraw and file it.
Okay. Right, Mr.
Also,
R. Sharma, law enforcement for the petition. Says that he may be allowed to withdraw the petition with liberty to file a plea. Mr. S. Das appears for the respondent. For the higher education department. Chair of the petitions council is allowed, this petition dismissed and withdrawn, comma, with liberty of plea.
Item 47 from supplementary list.
May please. Regarding the advance increment to the research for the acquire of PTL,
So you want a similar order?
Lordship. I've heard your Lordship though.
If the petitioners fulfill, my lord, the criteria.
Actually, only
Yes.
then. It'll be in terms of the order,
Lordship.
that increment, One increment.
Increment, your Lordship.
that increment that had been granted, it was withdrawn.
Lordship.
Correct?
Okay.
It was withdrawn because that became a necessity. It became an eligibility criteria.
Lordship.
That has not been, that judgment has not been disturbed. That is, Goswami's judgment has not been disturbed.
My
It
lord,
has not been challenged.
My lord, here in this one ordering of the coordinate bench, my lord.
No, I know. Those coordinate bench all relate to Justice Goswami's order. Yeah, you are talking of 21, 23 judgment orders. He's talking of some 2015 or 16, I think. I don't know. What is that judgment? I don't know. 2000, when was that? This posed off.
16.
2016 judgment.
Lordship.
That's what. Right. Third, Mr.
As to say,
Yes, to say, let us ask for the petitioner who submits that the petitioners are all serving as assistant teachers,
teacher,
subject teachers, also assistant teachers,
assistant teacher,
assistant teachers in different high schools,
high school
and
higher secondary.
higher secondary schools in the state. And in the course of their employment, they have acquired higher education qualification of BEd degree from UGC recognized universities and colleges
Lordship.
approved by the NCT. Correct?
Lordship.
The petitioners thus claim one advance increment in terms of the OM dated, OM number FE full stop 1/98/1 dated 7/3/1998, issued by the Commissioner and Secretary to the Government of Assam Finance Department. The petitioner's counsel submits that the said OM dated, no, submits that the benefits provided on the OM dated 7/3/1998 had been withdrawn by a subsequent notification dated 22/9/2014. Full stop. However, the subsequent notification dated 22/9/2014 was set aside by the judgment dated 16/12/2015 passed in WPC 6241 of 2015. Correct?
Yes.
Full stop. The petitioner's counsel submits that the petitioners have accordingly filed representations before the concerned inspector of schools claiming benefit of one and advance increment in terms of the OM dated 7/3/1998.
Okay.
He submits that the writ petition can be disposed of if a direction is issued to the concerned inspector of schools to take a decision on the petitioner's representation for grant of one advance increment in terms of the OM dated 7/3/1990. He also submits that this court in various orders passed in WPC 3384/2021 and wide order dated 18/12/23 passed in 6808/2023 had directed the concerned inspector of schools to take a decision on the representations of the petitioners therein with regard to their claim for one advance increment in terms of the OM dated 7/3/1998. Mr.
Yes, sir, Rabba.
Learned Counsel for the
BTC.
submits that he has got no objection to the prayer made by the petitioner's counsel. Full stop. Next. In view of the fact that similar orders have been passed by this court in cases involving similarly placed petitioners in WPC 6808/2023 and in WPC, the other one, huh? That is WPC 3384/2021, comma. The present writ petition is disposed of with a direction to the respective inspector of schools to take a decision on the petitioner's representations for granting them one increment in terms of the OM dated 7/3/1998.
One advance increment.
One advance increment, that's right. Actually, I didn't say advance. One advance increment. On their, in terms of OM dated so and so, as they have acquired the higher qualification of B.Ed/BT. /BT, huh? Anyone has acquired BT? No, all B.Ed.
All beer.
All B.Ed. So BT is not required. So BT you got, huh? All B.Ed. The writ petition is accordingly disposed of. Then I think 38 and 39 also same order.
Same
order.
Second 40.
Keep the plan.
Wait, please. Your lordship has gone all through.
No, not gone through. Tell me.
My lord, here, my lord, the petition is agreed, my lord, is the governing body of a private college, my lord. My lord, it is totally private college and it was affiliated to the Guwahati University,
Huh?
affiliated to the Guwahati University, my lord, as well as NCTE, my lord. Now, while the governing body as well as the principal has been working in their own capacities, my lord, what happened, my lord, the district commissioner, my lord, district commissioner of the Nalbari, my lord, had directed the inspector of school Borpeta, my lord, sorry, Nalbari, to take over the charge of the principal, my lord. And it is not at all permissible, my lord. It is a private institution, my lord. A district commissioner cannot, my lord, invoke such power, my lord. So he can direct anybody to take over the charge of any of institution, my lord. It's totally illegal, my lord. Moreover, my lord, and if there is any complaint against the principal, that is
Then why do you come to the writ court all the time? Before? In
because
the earlier
multiple
writ
parties are
petition.
there, my lord. Other parties are there, my lord. But district commissioner cannot, my lord, interfere in this manner. My lord, if there is,
Yes.
if there is anything wrong, my lord,
My lord, I am looking for the caveat. I have not received the copy. Yesterday I was not available actually.
Give it a.
yes,
Yes.
I have.
No.
Please,
When did you give? When did you give?
Just I am telling, my lord. Yesterday I had contacted more than 7 or 8 times.
No, I
The
have
council,
replied also. I was not present because my two juniors are at the civil court Borpeta. I was engaged in deputy commissioner's office. I could not come. That
Even
is
my
the
lord,
position, but I don't know what
even,
is
even,
there in.
even my lord, his clerk was also contacted,
No,
my
no,
lord. I had
it is
approached
not
the
my-
clerk, my lord, and I have informed him also. So that I
It
can
is
serve
not
the
my
copy through his clerk, my lord. But he did not allow his clerk to accept the copy. Only the
Why not?
malversation to not to get their case listed, my lord.
No, not
Yes.
this.
Repeatedly, my lord.
Let
Why
let
should
it be,
I
my lord,
punish, my
let
lord?
it be fixed on.
And moreover, my lord, can
I
you see their
will go through
intention, my
this.
lord? That inspector of school, my lord, while taking up the charge on 18, my lord, Yomoton, my lord, immediately they had taken over the charge, my lord.
Whatever.
And immediately on 20th, my lord, he had issued the letter to the all the bank manager, my lord, to freeze the account of the institution, my lord.
There is a lot of.
Only to install the procedure of the institution, my lord.
My lord,
Well,
that is not
there
the
are so
fact,
many
my
things,
lord.
my lord, behind
There
the
is
scene, my lord. So
as
many
far
things,
as
my lord.
my information is
In
concerned.
fact, my lord, what
Two
let-
repetitions-
let-
Just a minute. Let him speak.
my lord,
Well, this is
what
not a
happened?
fish market.
The dispensing body has earlier, my lord, had filed 2 writ petition, my lord, against the governing body of the present, my lord. But subsequently, they had withdrawn that writ petition. 2 writ petition they have withdrawn, my lord. Immediately after withdrawn, my lord, that they have initiated this process, my lord. Because in the earlier writ petition, my lord, the one of courts had directed to maintain status quo, my lord. Since there was status quo, my lord, they could not touch the governing body as well as the principal. Since the principal was also ex officio member of the governing body, my lord. Now, my lord, immediately after withdrawing that case, my lord, they had moved this matter. And inspector,
So it's a private college.
yes, my lord, private institution, my lord.
And the DC has asked the inspector of schools to take charge of the
Yes,
post of
yes, my
principal.
lord. My lord, even without informing the governing body, my lord, of the college, as well as the university.
Can that be done? I don't know. Can that be done?
My lord,
Tell me the law.
earlier 2 repetitions were there. As per my information on
He had
concern,
withdrawn himself, my lord.
that principal
Just a
has
minute. Just a minute.
that principal has attained the superannuation age.
Huh?
His age is
Principal has attained the
superannuation
superannuation
age,
age.
and he has written the letter himself.
Yes?
That principal, earlier principal, he has written letter to the governing body that I am retiring on such and such date. So my term may be extended for at least 2-3 weeks for
Week.
completion of B.Ed education. B.Ed examination was going on. There's lots of things are there. Without the copy, I cannot submit. So
My
at
lord,
least Monday, my lord.
That is not at all
2
the
days
case, my lord.
will not make any difference.
My lord,
Monday.
What is the retirement age of principal?
my lord, private college, my lord, is 65 years, my lord.
55 years.
65 years. Even, my lord, it can be
So-
extended.
Huh?
Even, my lord, it can be extended, my lord.
I don't know. Is
Like,
it
Yes,
65?
my lord, this is the.
Are you following any rules regarding age?
NCT rules is there, my lord.
NCT rules
Yes, yes, my lord. I
says
can
how many?
already
65 years.
Yes, my lord.
And let us see what is your age in your writ petition. You are 66 years.
Yeah. 66.
Here, so you said principal of a college is only for 65 years. Your affidavit says that you are 66 years.
No, that can be
That
extended.
means
That can be extended. That can be extended. That can be extended. That is as per guideline.
we'll
of the
take it up on
NCT.
Monday. We'll give you a copy.
My lord, till date, my lord, no.
Monday.
No, my lord, kindly see, my lord, there. What is there? Kindly see, my lord. Just one moment, my lord. What they are holding, my lord. They are teaching
Mr.
every account,
Counsel,
my lord.
you see, I hereby undertake to serve the copy of the writ petition to the caveator as and when the counsel for the caveator will be
Yes, yes.
available in the court.
Yes.
So give him a copy.
My lord, copy, I am really from yesterday, my lord. Yes, my lord. We are present, my lord.
Obliged, my lord.
Now, my lord, their action, my lord, that can be, my lord. Otherwise, my lord, my lord, I cannot express in word, my lord, what they are doing, my lord. Because
You
they are-
cannot, if you cannot express, then what do you expect? How do you expect
What-
me to know what's
what
going
they
on?
doing, my lord, they are running after the closing of the institution, my lord. If prestigious institution, my lord, it was established by the prestigious people of the locality, my lord. Highly qualified, my lord.
We are the parent
Those
body.
persons, my lord, the present body, my lord, earlier present body, they have already,
We
my
are the
lord, they have
parent
already
body.
driven away, my lord. Now the present body, my
submit
lord, they are
everything
just
on
like
Monday.
goons, my lord. They are just like goons, they are taking over everything. Educated person cannot face them, my lord.
He cannot unless.
My lord, yes, my lord. That educated person cannot face them.
But you just told me just now.
Really sorry.
No,
to
no.
use that word, my lord.
You just
Because-
told you just told me just now that the age of retirement is 65 years.
Yes.
But your affidavit shows that you are
No, no,
66 years.
affidavit, my lord, that is shown by the, my lord, that's not.
That
the
is shown by
PCB.
whom?
That is the, my lord, member of the governing body, my lord. Authorized member of the governing body.
Oh, member of
Not the
the
principal.
another principal.
No,
Oh.
governing body, my lord.
And principal is how old?
Principal is 65 years old, close, my lord.
Huh?
He is 166, my lord.
Yeah, principal is 66.
66 years, my lord. He is
Then?
166, my lord.
Huh?
Because it can be extended, my lord.
So
That
was
is
it?
the existing rule, my lord. And city rules there, university guidelines are also there. I have already annexed, my lord, the NCT guidelines.
No. As per the NCT guidelines, show me what is the age of a principal, retirement age of principal?
I am showing, my lord. Can we come to page 58, my lord? It's 58, my lord. Well, can we come to the note, my lord?
Ah,
Note, my lord.
yes, please read note.
Yeah, my lord. In the event of non-ability of eligible or suitable candidate for the appointment of principal head as per the above eligibility criteria, it would be the permissible to appoint retired professional head or educational on contract basis for a period not exceeding 1 year at a time till the time the candidates completed 65 years of age.
So he's 66.
66, my lord. Definitely, my lord. And moreover,
And what is your prayer? You want the principal to continue.
not only the principal.
You appoint
Because-
you
no, my lord.
you appoint some
I
other
have
head.
already,
Mr. Counsel, you
My lord.
please appoint some other principal. Simple.
no, my lord.
End of the matter.
My lord, on the principal, my lord, they had appointed some other person, my lord, to take up the charge.
Huh?
That is why
The government
that,
official.
that district commissioner.
Okay, you appoint some other principal. That's all.
Yes, I have left, my lord, page 69 is there, already there. I had published advertisement. Page 69,
69.
yes. No, why it is so urgent, my lord, to the deputy commissioner, my lord, to appoint the extent of the charge of the.
But just now you were saying that the principal is still continuing also.
The principal, my lord, his action of principal institution cannot be run, my lord. So that is why he is still continuing. But process is under 69, kindly see. There is a published in the Assam Tribune. And last date is, my lord, 2/4/2025.
So 2/4/25 was 1 month ago, more than a month ago. Now it's
2/4/25 last date, my lord.
last date. That's
Yes,
what I
sir.
said. That
It is
was
March.
now it's March. Which date? March.
It was published on, my lord. I'll say, my lord. It was published on 69.
Today is 21st March.
No, it was not published today, my lord. It was published earlier, my lord.
I know.
That's why.
Then you have had 1.5 months to fill the post of principal. They're not filling it up.
Because, my lord.
Monday,
there
Monday,
is- My lord, there was a.
Monday.
Not-
Heard
Yeah,
Mr. S. Hockler, counsel for the petitioner. Also heard Mr.
Yes, Roy, my lord.
S. Roy, learned counsel for the caveator, respondent number. Respondent number dash, huh?
This one number.
Uh, Respondent number says so. The petitioner's counsel submits that the principal who the principal, no, the earlier principal is 66 years of age and he has been illegally ousted by the district commissioner who has appointed the inspector of schools as in charge principal of the college. This is the matter of Monday. And as much as a copy of the writ petition has been provided to the caveator only just now. Only now.
My lord,
Monday.
no further course action, my lord, because can we see, I have.
What coercive action can there be?
They are, freeze the bank account, my lord. They cannot be paid the college lecturer. How they can college make?
When was it closed? When was the bank? When was it closed?
Here can we see, my lord. He had taken over charge on 18, my lord, and on 20th, my lord, he had written the letter to the, because their intention was that, my lord, to close to shut down the college, my lord. So that the governing body cannot run the college. So, my lord, whatever their fund, my lord, that can be utilized by parent body or whatever. And moreover, my lord, in that letter, my lord, if lordship go to.
No, we will see. There might be something more than I,
Just,
you know.
my lord, can
Nothing will happen. You see, thank God that it's closed. No transactions will
Yes, my
take place. So
can
it's,
we see page 73 also? Just a moment, my lord.
no.
One
Monday.
moment, my lord. One moment, man. Can you see page 73, my lord? What they.
You tell me. I will not.
There, my lord. Therefore, you are requested to hand over all the official particulars and belongings to the undersigned within 7 days from the date of issue of this letter. This was issued on 18/3/25. 18/3/25, my lord. There was 25. It was the date, my lord. 7 days. But we're passing out the 7 days, my lord. They initiated this thing, my lord.
We'll see on Monday.
Your lordship is there, my lord.
It's not the end of the month. Your salary, everything is paid only at the end of the month. 21st, we'll see. He needs some time also. He's just been given the copy just now.
Look, because yesterday I have contacted several
You
times.
could have given it to him early in the morning
Last-
at around 10
no,
o'clock,
he-
10:15.
I'm
lord,
sitting here,
in
my
last-
lord, from
Huh?
item number 4.
Ah,
Last,
Sitting here,
sitting here.
yes, from item
my
number
lord,
4.
what happened? What happened last?
He
Court
is
three-
submitting
court said-
regularly,
court
so,
five calls, my lord, he did not. He did not
Lordship,
receive.
I have to mention one thing. That principal himself written letter on 15/9/2022 to relieve him from the post. But still he is holding. That is the thing I know now. But I have to go through the petition itself. I will
Until
submit everything in
unless
the
I found some other, how I can keep the vacant post of the principal such institution, my lord. It is up to the governing body. He is looking for the governing body. How the district commissioner can't.
Well, but how come you are still being a principal after 65?
Well,
I mean, not you, your man. How is he? How is your
Because-
man still as a principal?
as per the NCT guideline, my lord, he can be extended.
No.
I'll
You-
show,
you-
I'll show,
you
I'll show
just-
Monday, I'll show you Monday.
Item,
Your lordship, kindly better be adjourned, your lordship, and fixed on Monday, your lordship. The it has been
Hey.
right. Yes, your lordship. Kindly. It's on Monday. Your lordship.
why?
He's on legs, your lordship, and another.
We can wait
Your lordship.
at 2 o'clock. What?
2 o'clock.
No,
Oh, your
he'll
lordship.
be on legs again.
Your lordship.
3:30 also we can wait.
Your lordship, because the engagement is from means he will appear through VC, your lordship. He is at
So we are ready.
in,
He can come anytime.
he's in Delhi, your lordship. That's
Huh?
why he's in Delhi, your
So
lordship.
that's why we are allowing him VC.
On-
That's the one I think that VC was there.
Yes,
We are allowed it.
On
already.
Monday, your lordship. Will be
I
possible.
don't think you want adjournment through VC, you allowed it, now you're right. Who is the council from
R.
Delhi?
Biswas.
Huh?
R. Biswas.
Right. Adjournment prayer has been made by Mr. R. Biswas, the counsel for the petitioner. Though his prayer to be heard through VC had been allowed this morning. The facts of the case is that the petitioner was suspended on 31/10/24. And the review of his suspension order was made on 27/1/25. List the matter on Monday.
Of like-
My lord, the petitioner.
Item?
Eight,
Item 8. Yes,
but the petitioner earlier approached this honorable court, my lord, and this honorable court, in the writ appeal, my lord, order dated 9/3/2022, the page 63 to 66, my lord, has directed, my lord, to follow the mandates of the office memorandum dated 5.
so you want seniority list to be made?
Yes, yes, lordship. And they have thought that the underqualified persons who are not eligible as per UGC norms have been appointed right and left, my lord, by the college principal. That cannot do. When
Yes,
Notice me, Malad, otherwise, his post is not permanent, Malad.
huh? Otherwise,
His post is not permanent, my lord.
question of post, permanent of the post, my lord, this is not the issue, my lord. Already this honorable court has said, my lord, whether in a provincialized college, my lord, when there is.
okay, right, heard Mr. Yes. B. Prakash, no counsel for the petition. Who submits that? Despite the division bench of this court, wide order dated 9/3/22, passed in WA 92 of 2021, having directed the college to appoint the head of department of Computer science.
Computer science
Computer
and
an
application.
application. The same has not been done as the seniority list of the UGC qualified assistant professor of the computer science department has not been finalized. On the other hand, the respondent number 5 and 6 have been appointed as assistant professors
Yes,
of the department, though they do not have the
UGC
eligibility criteria as prescribed by the UGC. He also submits that. He just submits that. The respondents number 5 and 6 cannot be designated as assistant professor. And they should have been designated as instructors.
instructor.
Issue notice returnable in 4 weeks. Mr. S. Das accept notice on behalf of
I'll be appearing for, Malad, 1, 2. 1 and 2, Malad.
1 and 2. Who else?
I'm appearing for respondent number 7.
Mr.
K.
K. Jain for respondent number 7.
Number 8, your lordship.
Mr.
Y.N. Mohanta.
Y. Mohanta appears for respondent number 8. Ms. S. Priti appears for. Oh, not there. Who else? You are appearing for Midas for
I'll be appearing for 1 and 2, my lord.
1 and 2. What about 3, 4, 5, 6?
3, 4, 5, 6, my lord, notice will go.
Notice,
and,
okay, petitioner to take steps for service of notice upon the respondent's number.
Regarding 7, my lord,
3 to 6 by registered post with AD within
3 days.
3 days. Let the matter out of
my
the
lord,
My
regarding
lord, one
7,
thing, my lord, in the interim, my lord, I pray for my lord, the post of HOD, my lord, should be filled up by following the procedure, my lord. As
They
per
have not filled up. They
they are going to fill up
no,
because the existing HOD will term will be complete in the month of April, my lord.
So you wait to wait. Let it be. Let the you say list the matter on.
And
List
it
the
will be
matter. Give before April.
Yes,
No, ending in April, no.
yes.
List the matter on 2024. Huh? 24.
Yes.
Obliged.
Absolutely.
18.
24/4.
Pursuant to your lordship's last order,
Ah.
we have filed an affidavit.
Sir, record of name, amaru name, record of name, chalu.
Okay, affidavit to nine.
Record of name, amaru.
officer,
I
but
think-
it's not there in the record.
It's not
No,
in
it's
the
not
record
yet.
also, my lord.
It's not yet.
Yes, my lord.
My lord, along with the affidavit, let it come up next Friday.
But my lord, one thing, my lord, since the new document has come up, where there are signatures, my lord, contrary to our stand, my lord, we'll have to seek instruction in that regard.
Ah.
No, no,
So you
let them
started
have the
to-
instruction, my lord. But only thing is our instruction is, my lord, what they did, they have taken instruction from director's office. If they reach out to the district elementary education's officer office, they will get all this. Only problem is perhaps they got it from director. That's why they couldn't get it.
Let them make it instruction.
No problem.
Okay, so right. Mr. B. Prakash, Mr. K. Chaudhary, Land Senior Counsel, submits that as per the document submitted along with the additional affidavit, the same shows that
All
the
members
select
of the-
list contains the signature of all the screening committee members. He submits that the documents were procured from the office of the,
No, Lord, we
He
made
submits
a
that-
amendments.
Ah.
We procured from the persons who were at the helm of the affairs.
okay, anyway, full stop, cut that aside. Mr. B. Gogoi and Mr. N. J. Katane, learned counsel for the respondent, shall obtain instruction as to whether the documents annexed to the additional affidavit of the of the petitioners, of the petitioner additional affidavit are genuine or not. List the matter. I think they'll need some time then.
Yes, my lord.
After you.
Let us take a chance before the Bihu meeting.
I don't know.
9th of April.
9th,
9th is witness.
9th of April. Okay.
Well, it's 21st today.
9th. This is the matter on
Yes.
9th.
Okay.
You're right.
My lord, let it be on
Registry to,
11th, my lord.
no,
9th.
11th, no. 11th will be difficult. I've got to go somewhere.
10th, my lord.
You see, that week will be a motion
Right,
week.
right.
Keep that, entire week. will be a motion.
Let it be on 22nd, my lord. April
My lord.
22nd.
is a Tuesday, my lord.
Obliged.
Registry to, place the petition additional affidavit on record.
And the copy may be served to us. my lord.
I thought they served you.
Where please, my lord?
Yeah, lordship, the university has not responded.
Item.
Yeah, the Guwahati University has not filed their response, lordship.
No, what is your case?
Lordship. There was an advertisement in 2018, lordship, page 20.
Yes, for recruitment to the post of assistant officer.
Yes, lordship.
Then what happened? Then
Then
you
second
applied
ad-
for the same.
Second advertisement was issued, lordship,
A second advertisement issued when?
on on 21/7/2020.
Then,
Then again, one corrigendum was issued, lordship, on 28/8/2020,
when?
increasing the education qualifications so as to enable the respondent about
Just a
private-
minute, just a minute.
Right.
So the first advertisement was issued when?
First advertisement was issued on
Lordship, I'm sorry, my lord, I may be allowed to submit, my lord. Because as per number 1 and 2, Guwahati University, PJ Fikan is not well met, my lord. He just now informed me, my lord. So he needs some time to file affidavit. Affidavit is ready, my lord.
No, no, might not be required. We might have to dismiss it straight away.
I was told, my lord, that's
No,
why
no, I'm just.
I'm appearing on behalf
We
of.
see, I'll see if he has a case. If he doesn't have a case, I will adjourn. If he doesn't have a case, I'll dismiss.
I have a case, Lord.
I am not in.
That's why I'm hearing you.
Yeah.
Let me see. First advertisement. You've got to be careful
Date
now.
is not there, Lordship.
Huh?
Date
It is not there.
First advertisement number is there, and as
Okay,
LPS.
second advertisement,
second advertisement dated 21/7/2020.
21/7/2020. Then third advertisement,
Then corrigendum was issued
corrigendum,
on 28/8/2020,
28/8/2020.
decreasing the qualification
Increasing qualification.
from master degree to graduate. To facilitate the from master degree, earlier it was Lordship,
From master degree?
to earlier it was essential qualification master in business administration MBA with
Show me.
specialization
Let
in
us
page 20, Lordship. First advertisement,
page 20.
20,
Yes.
first advertisement.
Master in business administration. Okay.
MBA with specialization in human resource management having at least 55% of mark or its equivalent grade B in the UGC 7 points. Then Lordship, in second advertisement also, essential qualification at page 22. Master degree in libraries, state officer page 23. Essential qualification BTech BE degree with master in business administration.
Essential qualification out there is BTech.
Yes, Lordship.
B degree with master in business administration.
Yes, administration.
Okay, then
Now the corrigendum was issued. Why, Lordship? To facilitate that private response number 3
corrigendum issued.
on 28/8/2020, page 27.
Yes.
State officer, essential qualification, graduate in any discipline. What has prompted them to decrease the essential qualification from master degree to graduate, Lordship? This is what? This is a metaphorical, Lordship. And I was recommended by the selection committee.
You were recommended by this 28/8/20.
Yes, Lordship, selection committee.
Where?
Lordship, annexure 6. Type copy, Lordship, page 35. 6A. Serial number 5.
Yes.
I am Amrit Narayan.
Okay, you are recommended. When is this date of recommendation? 21.
11/4.
Okay, after 10/3/21.
Yes, Lord.
Is it? Then
Private response number 6, Himanshu Kumar Das, recommended subject to relaxation of essential experience on the basis of certificate given by the registrar secretary.
where is that?
That page 35, Lordship.
35. 35 years recommended.
I am recommended, and this private
Acha,
response number 3,
Himanshu Kumar Das recommended
yes,
something.
private response number 3, recommended subject to relaxation of essential experience on the basis of certificate given by registrar and secretary.
Where is the question now? Subject to relaxation.
Sir,
So
I was recommended.
so this respondent number 6 has been appointed.
Yes, Lordship. The horse.
Okay. We'll adjourn the matter.
I have-
Mr.
1 week time required, my lord. Affidavit is ready, he told me, my lord.
Mr. What is his adjournment prayer has been made on behalf of Mr.
1 and 2,
No, his council's name.
PJ Fukan.
PJ Fukan,
Yes,
and
sir.
council for the respondent number 1 and 2.
Time for response number 3.
It is also stated that Mr. PJ Fukan had given information that affidavit is ready on behalf of respondent number 1 and 2. Mr.
MJ Gogoi.
MJ Gogoi appears for
Response number 3.
respondent number 3. This is the matter after the week.
Lordship, date may kindly be fixed, Lordship.
I'll give it
31st,
April.
Obliged.
Item 20.
Yes,
Last occasion, my senior.
yes, Mr. Mahanta. So you see, he says that let the issue be decided by the secretary.
No, what issue?
He says that
That-
as per the regularization order, you are senior.
My lord,
As per date of joining, he is senior.
that is, yes, that,
So let the secretary decide whether which should be the
senior. Who is the
yes,
senior?
which criteria should be followed?
No,
The
my
date
lord-
of joining or the date of
No,
regularization?
that is not the case here, my lord.
Okay.
Your lordship kindly see in his earlier petition, seniority has been issued. That is, my lord, that is, my lord, that is
That is-
decided. Here, my lord, he says, his petition, contention of the petitioner, that my regulation order, which was in 1994, now he came to know that my regulation order in 1994, that's why he challenged it, my lord. That challenge is made, my lord, then, my lord, it has to be heard. So,
Okay, so let us see the earlier decision of this.
yes, I have annexed in my petition, my lord.
In the petition also, Lordship, annex L page 48, Lordship,
Page 48.
48. Read petition.
Okay.
So out here, Suleiman Ali
Lordship, is the
is
petition
the
number
free petition, and he is the respondent number
6, earlier also 6.
six.
Earlier, yes,
Okay,
5.
but name is not reflected here. Right?
Earlier it was challenge, Lordship, is
Anyway, okay, item number 6. Then let
earlier
us see
challenge
the,
in the context of class and cadre, Lordship.
Huh?
Then court that, Lordship, will find place.
Para 7, page
Para
50, page 52.
Place 52, Lordship.
yeah. Admittedly, the respondent number 5 is senior to the petition.
In
As
that
per the material replacement, yes. So that is, that is until and unless that been challenged.
Huh?
Until and unless that is not been challenged, my lord. There is a finding of the court, my lord.
Lordship, then
This court is therefore being the no the order. So respondent number 5, he's senior to you.
that, Lordship, in that writ petition, that was not the issue. Seniority is not the issue, Lordship. In class and cadre context was raised, Lordship. Whatever may be the Lordship.
No, but then you see, this now will come. This
Lordship,
is an observation made.
Lordship.
Now you have to go by way of a review.
Lordship. And subsequently, we came to know that his entry is illegal, and we have challenged his entry also, and subsequent regulation, Lordship. His entry to the post, Lordship. Kindly have a page, his initial appointment, Lordship, is 24, Lordship. Page 24, Lordship. Subsequently, we came to know about this. 5194, Lordship.
Yes.
Appointment is purely temporary and may be terminated at any time without prior notice, Lordship. Temporary 3 months, Lordship. Initial appointment, Lordship. Page 24, Lordship. And next page, page 25, Lordship, column number 6, Lordship. He was asked,
Just a minute.
Lordship.
So this is not regularization order.
That was temporary initial appointment, Lordship. And he was asked to join within 10 days, page 25, Lordship. Page 25, column 6, Lordship. Page 25, column
Yes.
6. He was asked to join within 10 days, Lordship. He joined after 20 days, Lordship. No extension order, nothing, Lordship. The joining letter we have annexed, page 27, Lordship, with the joining letter, Lordship. On 21/1991, there is nothing on record that his 10 days was extended. And
there is selection procedure, no advertisement, nothing, Lordship. Initial appointment, illegal entry. And that is affecting my service, service benefit, Lordship. That is my contention.
Well, where is the bar? He's gone in a bit late, that's all. They have not stopped him.
No, my
There
lord,
is no continuation.
I have
order,
answered,
Lordship.
everything I have annexed, my lord.
Then subsequently, page 29, Lordship, is his regulation order, Lordship. Page 29, Lordship. 31/12/1994. Initially, he was appointed on 5/1/1994 for 3 months. 31/12/1994 regularized. After 3 months, Lordship, 11th month, no extension, nothing on record, Lordship, nothing on record, nothing on applicability. Either by the director or by the responsible for 6 months. 3 months appointment, after 11 months, he was regularized. You have no person given, but this is affecting my service benefit, Lordship. Initial appointment 3 months, join after 10 days, Lordship. And regulation order 21/1994. 13/12/1994. Even though with effect from 1/7/1994, but 3 months, in the meantime, 3 months elapsed, Lordship. With effect from 1/7/1994. The 3 months temporary appointment, Lordship, was never extended, Lordship, nothing on record. That is the issue. That may be examined by the secretary. That was limited prayer, Lordship. That is,
Why?
this honorable court may also examine,
No,
Lordship.
you see, leaving that aside, when the earlier order, when the earlier writ petition has been disposed of,
Lordship,
and there is already an observation that he's senior.
Lordship.
Now, can we go against that order?
Lordship, seniority observed on the basis of statement of seniority which is annexed with the writ
No,
petition.
no, you have got to go and clarify with the same court. You
Right.
go and clarify with the same court.
And in that Lordship statement, date of regulation is another date, 21/1994.
Whatever it is, you have to go to that court. You go to that court and say that this observation made that he's senior to me is wrong. Or you go in appeal. How now can I, a coordinate bench,
Right.
say that what has been observed there is wrong? Can I do that?
On that, in the context of seniority, Lordship cannot. Lordship,
Then
in the context.
That's the entire issue. The entire issue is seniority here.
Lordship, I'm challenging this regulation. Regulation, Lordship.
Regularization.
Yes, Lordship. My prayer may be, Lordship, in this
You challenge the regularization.
regulation, because
And
after
regularization made in 94.
94, Lordship.
Why should I go into that effect now in after?
You
You have come after 28 years.
Lordship, I came to know about this orders, Lordship, only during the pendency of that earlier proceeding, Lordship, in 2022. He is from different school, I am from different school. Transferred.
Okay, wait. So in the earlier writ petition, what was the issue?
Issue was class and cadre. I raised that I'm senior class. Lordship.
Seniority and.
You're a senior.
Cadre, insert.
In charge?
In charge head principal of that particular school.
In charge principal.
Lordship.
So seniority was an issue there also.
So, my lord, that he says that I should be.
Higher
in
cadre, Lordship.
Not only my lord, in fact, my lord, in earlier, there is a direction to go for regular, my lord, regular principal. Within 6 months or 3 months, there is a direction also in earlier order. So now, my lord, after that, now there the order which was my service was regularized in 1994 doesn't mean challenge in this speaking. And he says that there is no interview. Everything I have annexed, my lord.
Let me see. That's it. That's all.
That's for that part. That it was regularized after elapse of 3 months, Lordship.
What does it matter?
Initially appointed for 3 months, Lordship, that regularized in after 11 months, Lordship. There is no extension, temporary appointment.
No extension of that initial appointment.
Yes, Lordship. That was
That initial period of 3 months, no extension.
further extension, so. Nothing.
No extension of initial 3 months.
Lordship.
So that's your teeth.
Lordship. And that is affecting my service.
Yes. You just show me the
Yes, sir.
extension.
Everything, your lordship kindly page 55.
50,
55 of my affidavit, my lord, that continuing page, my lord, 55, para 8. Sorry, para 5.
55,
Para, page 55, para 5,
page 55, para 5.
my lord. 55,
I've got page
59, 59, yes, sorry, 59,
59.
para 5, my lord.
Yes,
That with regard to statement in paragraph 3 and 4 of the petition, this deponent denied the same to be correct. This deponent beg to state the statement made in this paragraph not correct. The deponent beg to state that by the order dated 5/1/2019, issued by the Inspector of School, Dorong District Circle, Mongolo, his deponent was appointed as a Sanskrit teacher of the Bongange Borigaon High School on ad hoc basis. Accordingly, on 21/2094, joining the said post. Thereafter, on 24/5/2000, the respondent number 3 issued a letter to the deponent by which the deponent was asked to appear before the interview board constituted by the district level selection board in the Dorong, regularize of his service as their teacher on 9/6/1994 at 10 a.m. the local circuit house Mongolo, and accordingly the deponent appeared the interview on 31/12/1994. The respondent number 3 issued an order by which the service of the deponent was regularized with effect from 1/7/1994 in the post of Sanskrit teacher on the recommendation of the district level school selection board, Dorong. Now, my lord, your lordship kindly see annexure 1, annexure 1, my lord. Probably page marks are different, my lord. Annexure 1, my lord, that affidavit.
yes.
That order was passed on 5th January, my lord. That was for temporary, my lord. I was given a, my lord, scale pay.
Yes.
And then, my lord, next annexure 2.
Yes.
That was issued on 24th May 1994. Interview for regulation service. That was, my lord, you are requested to appear before the interview board constituted by so-and-so, certified as so-and-so. No TAD will be. Accordingly, my lord, on the basis of that letter, my lord, I appeared, and my lord, annexure 3 page, my lord, annexure 3, my lord, your lordship kindly see. My regulation order was passed. Annexure 3, my lord. That was order was passed on 31/12/1994. On recommendation of district level selection board, Dorong, in the service of the following teachers appointed on ad hoc basis of the provincial school from time to time have been regularized of their present posts in their own grade and scale pay with effect from their so and so. Name of the candidate, Kishore Kumar, the Borigaon High School, 1/7/1990. So that is my order. So now that order has been challenged, my lord. I don't know on what ground,
Page 70.
my lord.
You mean page 70 has been challenged?
Annexure 3. So initial my appointment was ad hoc. Then I was asked to appear before the interview board. I appeared in the interview board. I appeared, and my service was, my lord, regularized with effect from 1/7/1994, my lord. His service was regularized in 1996, my lord. So, my lord, that which was settled in 1994, my lord, in 2025.
Was there any scheme under which you are regularized?
My lord, that record will speak, my lord. I do not know, my lord, even.
We have also, affidavit has also filed your lordship. Your lordship.
No, in that event, were you also regularized under any scheme?
My entire school was regular.
Huh?
Provincial lights lordship. School.
Okay, yeah.
Entire school.
Huh?
Entire school lordship, all staffs.
Your school was provincialized. So you came under the Act 2011 Act.
Earlier than lordship.
2011.
96 lordship, 96.
Yes, madam.
We completely stated that the stand and taking our stand, your lordship, page 85.
Yes, page 85 what?
Your lordship, I would like to read, your lordship, the last paragraph.
Yes.
In the instant case, respondent number 6, that is Kishore Kumar Sharma Borwa, which is a MA BA graduate teacher Sanskrit of Kharupetia Higher Secondary School, received the graduate scale of pay with effect from 21/1994.
No, you see, one thing is I want to know. on how did the petitioner's service get regularized?
As per number
What are the basis?
Your Lordship, that is
Can
the.
you just regularize?
He
just like
was,
that?
he was a graduate scale pay with effect from 21/1994 and had completed 27 years, 11 months and 11 days of service as on 1/1/22. On the
No, no,
other,
he was regularized in 94.
1994.
How? What is there any?
As per Rule 25(4) of the Assam Secondary Education Provincialized School Rules 2018 as amended in
Madam,
2021.
that is 2018 rules. He was regularized in 1994.
1994, to mention it.
It's like saying, I am a lawyer today, but I am going to be born 25 years later. Is that possible?
As per office dated also, your lordship, in page 83, your lordship, we have stated one part, your lordship, respondent 6, your lordship, to hold the charge, your lordship. Being aggrieved, the petitioner, who is the subject teacher of Karupetia HS School, District Dorong, assailed the seniority of the respondent number 6, as well as office order dated so and so 22, allowing the respondent number 6 to hold the charge of principal of Karupetia HS School by filing one writ petition that is being number 1675/22.
So you are challenging the regularization order.
Yes, without extension. Nothing.
That is, you are hitting the wrong nail on the head. Anyway, so what to do? That's too much. I've got one meeting to go to.
Maybe taken on next. Ordinary maybe taken lordship.
Regularization to
Let's speak to you busy. After that, April. On the parties list the matter, April. We were it.
Ordinary.
This case, my lord, no affidavit has been filed by the respondent.
What is this case about?
Yes, my lord, regarding a non-provincialization of
Huh?
service, non-provincialization of service, my lord. In pursuance of the court order, my lord, the appeal preferred before the secretary, my lord.
So affidavit has to be filed. For what? What is wrong with this order?
Case 59, my lord.
What is wrong with the order?
Wrong, my lord, the one, my lord, Ratnakar, who died prior to, my lord, provincialization of service, my lord. And he is much junior than the petitioner, my lord. Then, my lord, kindly see, my lord, earlier order passed by
filed
the honorable court.
Post is personal post. One person is acquired, post will go.
Oh, it's a personal post.
Died prior to, my lord, provincialization, my lord. After provincialization.
But it's a personal post.
And prior to, my lord, provincialization, my lord,
How?
school authority, my lord, forwarded the recommendation.
You filed that affidavit?
My lord.
Mr. P.K. Bora, Lieutenant Counsel for the Elementary Education Department is granted 4 weeks time to file affidavit for it. This is the matter.
It may be fixed, my lord. 1 year, my lord,
No
seeking
hurry, no hurry.
taking time, my lord.
Next.
Item 22. Oblige.
May I please, sir? The impugned order is at page 23, annexure 7 is the impugned order.
Page 23.
Yes, Lordship. This is the order. This is regarding the selection of the headmaster in charge of a middle school. The seniority of the petitioner was ignored and this order was issued.
Yes.
Lordship, here my humble submission will be that since it's an issue of seniority between the petitioner and the private respondent, Lordship may remand back it to the director, who after taking a hearing will decide again. Lordship.
No, Lordship, the director has said on both sides. There
Huh?
are two, but director has said on the both sides. One seniority list they have prepared. As per that, I am senior. Thereafter,
in the affidavit, they have stated that he is senior because another seniority list was prepared.
Huh?
But
Another seniority.
another seniority list,
So
but that
two
was not
seniority lists.
so-called seniority list was prepared. That was not annexed, and that document was not produced.
Huh?
That list, what he is stating that he is
Let me
senior.
see the two seniority lists. Show me the two
Lordship,
seniority.
the
Page.
Lordship may kindly turn to the affidavit in reply that I have filed. Lordship, page 42, annexure 11 is the seniority list.
Page 42.
Yes, Lordship. The seniority list is at page 43.
Huh? 42 is
A forwarding letter by which the seniority list was forwarded
okay.
by
This
the.
is 3rd July.
Yes, Lordship.
This is the forwarding letter.
Yes,
And
Lordship.
seniority list, seniority is that page.
Lordship, this is not 3rd July. This is 7/6/2023. That is at page 42, annexure 11.
42.
Yes, Lordship.
Annexure 11.
Yes, Lordship. It
This
is the
is-
affidavit in reply.
Why don't you all actually affidavit opposition?
Lordship,
Why don't
initially-
you all paginate your pages as per the pagination done for my copy?
Oh.
I
Also,
cannot
here
come and
the continuation will be different. The annex,
Lordship, it is-
the flag mark C, Lordship.
flag mark C.
Flag mark D,
C.
that is the affidavit in reply filed by him.
Affidavit, that's flag mark D is affidavit in reply. To affidavit of the respondents number 3 and 5.
Yes, Lordship, this is the affidavit in reply filed by the against the affidavit in opposition filed by the respondent number 3 and 5.
Okay, it starts at page 51. Okay, anyway, so where? Page?
Page 42,
Lordship, it will be annexure 11.
annexure 11.
The page number is different.
Can you-
Okay, 7/6
Yes, Lordship.
is page 69, running
Yeah.
page.
Lordship, may kindly turn to the next page.
Page 70. Yes, petitioner is where?
It is petitioner is at serial number 2.
And respondent number?
Pankaj Sarkar, that is next him. It
Respondent
is
number
3.
5.
Yes, Lordship. Respondent number 5 is at serial number 3.
3. Pankaj Sarkar.
Yes, Lordship.
Okay, this is made on 6/7/23 by EO. And now where is the other seniority list?
Lordship, they have stated about that, but that was not annexed. They have not annexed any.
So what have they stated? Let us see. What
Yes,
have they
Lordship.
stated?
Lordship, is trying to the affidavit in opposition filed by the is respondent number 3.
Point number 3. Yes,
There they have stated.
para.
Lordship,
Lordship 6 and 7. Page 45.
Petitioner is at 2. Same thing. Respondent 5 at 3.
The same district authority forwarded another gradation list, Lordship. That was on 2nd of May.
Okay. So this is. So as per the block elementary education officer,
yes, Lordship.
the respondent number 5 is senior. According to the DEO, you are senior.
Yes,
So
Lordship.
let the director take a decision. This is a higher authority. Who are we to decide which? How can we decide?
Lordship, because the date of appointment, Lordship, if you go by the date of appointment, they have in the seniority list, date of appointment were mentioned. So by the date of appointment, I am senior. What they are doing, there was amalgamation of the schools. At that time, they have counted my seniority from the date of amalgamation.
That is not correct because the,
Date of amalgamation, date of appointment and date of amalgamation.
yes, Lordship.
So, date of amalgamation, okay.
My date
Now,
of
so
appointment,
they have taken the respondent number 5's seniority from the date of appointment.
yes, Lordship. That his was taken from the date of appointment and my was because
Or
I
the
was
date of
working
amalgamation.
date of amalgamation. That is why they have shown me as junior, and that cannot be. And higher qualification, if any, that will not attribute to, that will not disturb the seniority because the basic qualification BA I have. My appointment was on 2010-2019-93, and his appointment
2010
was
93, and his appointment was
24-1-2015.
15.
Yes, Lord.
And your amalgamation was
Amalgamation was in the year 2018.
date. Okay. So he's that way he's junior to you by around 22
Yes, Lordship.
years. Not 22 years. Yes, 22 years. Around
And
22 years.
all along the recruitment rule says that the post of the selection will be as per the seniority come merit, because merit will come after and seniority will be the priority. Seniority come merit. It is not merit.
So
come
the
seniority.
so you are both assistant teachers.
Yes, Lordship.
You're both graduate teachers or what?
Graduate teacher.
Both of you are?
Yes, Lordship.
From the time of joining.
No, initially I joined. That time I was not having the graduation because I have joined in
So
a
you started getting graduate scale of pay when?
I was granted graduate pay of scale with effect from 2018.
2018. And
Yes, Lord.
he got graduate scale of pay since when?
Yes, Lordship.
Since what? What do you mean yes? I'm asking you a question, you're saying yes.
Lordship, he joined, he got the scale from the date of join.
Date of joining.
Yes, Lord.
See, so
But that will not come because their amalgamation order, there is a policy, it says that you cannot lose the seniority.
let us see.
Lordship, that in my,
Let us see.
that is there in the, Lordship, in the seniority next, down below the, next, it is next to the seniority list. That is the annexer 12.
Page?
Page number will not tell you because my page number is 46.
Whose affidavit?
In my affidavit in reply, I have
Reply.
annexed the policy.
Okay.
This is the
In your
office
reply,
memorandum.
para?
Para, paras,
Lordship
7,
clause 16.
clause 6.
16 lordship.
Was 6. What? 6?
16 lordship 16.
The affidavit in reply, para? Not para, in annexure.
Lordship, in the affidavit in reply, it is in para 16.
There is no para 16. There is only
Para-
till para 7.
Sorry, in annexer. I'm
Annexer
talking about the
12 lordship. Annexer 12 lordship.
Annexer
Page.
12.
You please paginate, no? Otherwise we are, it's all page in your copy. Which page?
It is in page 49, my
49. Yes.
Para 16, gradation list.
How the gradation list will be prepared at the bottom lordship clause 16.
Each of the teachers shall be the teachers of the higher school after amalgamation / merger, and their status will be revised. After amalgamation / merger, the gradation list of the teachers or teachers of the school or district, as the case may be, has to be revised by incorporating the names of the teachers against the higher school in accordance with the higher his or her qualification and status. He or she will be the seniority as before, and his name or her name has to be placed in the appropriate place in such a way that he or she does not lose his or her seniority. So I'll get the seniority.
Yes, who's for the other side? For the respondent number 5.
Your Honor, Lordship, the respondent number 5 was given the post of headmaster in charge
Correct.
in the year 2015.
So the issue is, why should you be senior to the petitioner? Are you senior to the petitioner?
Lordship, the headmaster in charge post was held by B in 2015.
Madam,
Since I am the senior.
yes, you're the senior. Why are you the senior? Why should you be considered to be the senior?
because at the time when I was appointed as the headmaster in charge, the clause was that the headmaster in charge post should be held until the next appointment.
Correct. But that does not mean that you're the senior. Does it mean that you're the senior? Why do you say that you are senior to the petitioner?
Lordship, they have stated in their affidavit in para 5 of their affidavit filed by the respondent number 5. The respondent number 5 affidavit in para 5, they have stated
Yes.
that by order dated 22/1/2018, Nislamari LP School was amalgamated with the Nislamari ME School, and as such, the petitioner has became Nislamari ME School teacher after the date of amalgamation. Hence, he is junior to them. They are saying that it is from the date of junior. This is that is their step.
So you are from Nilachamari LP school
Yes, Lordship. Those
and they are from ME school.
Yes, Lordship. The policy of amalgamation says that I will not lose my seniority. So I will be senior.
Yes.
That is their step.
So what is the stand of the government? What have they said?
Government has not given any concrete.
They are just
stand.
giving two conflicting decisions.
That's why Lordship, after getting his reply, I'm praying that Lordship may remand it back to the director, who after giving a hearing to both the parties, will decide on the seniority, and thereafter whoever.
Let him take a final decision.
The insurance will be, because
That
it's only
can-
insurance.
But then this order should be quashed till then, because this order, otherwise it will create problem. That he is in charge of order. It is quashed, then remand matter may be remand back. This order, which I have said.
No, we will say that
Because this order, which I have
The
said,
moment
till
Lordship
3rd July,
decides to remand it back, the impugn order will automatically get quashed.
Lordship make
No,
quash this
Lordship will-
impugn order.
They will have to decide.
No, they will take a decision. I don't have
Lordship
any
will take
objection in that.
give a short period of time.
Unless it is quashed. Because
Then
unless
otherwise
this
school
order is
has to
quashed,
run, Lordship.
the school has to run. It has to be run for a certain time.
they can take the decision.
We'll give a time period. We'll say that the thing should be decided within one month or whatever.
Yes.
And the impugn order will be valid for 1 month only.
Yes.
No more.
Lordship,
We'll,
Then this may be quashed, and within 1 month they can take the decision.
sorry. We'll just say that it'll be decided by 1 month, and and if the decision is not taken within 1 month, the in charge order will go.
Yes, Lordship.
Correct. Heard Mr.
SN
SN
Tamuli.
Tamuli, learned counsel for the petition. Also heard Mr. S.
A Fukan for response number 1.
A. Fugad for point number 1. Mr. B. Chaudhary for the BTC,
Yes, my lord, 2, 3, and 4.
2, 3, and 4, and Miss,
D. Bangshari on behalf of SCDAS, respondent number 5.
you got it?
P. Bangshari,
Spelling?
PANGSHIARY. On behalf of
BANGSHIARY.
SHIARY.
Bakshari, huh? On behalf of so and so, counsel for the respondent number 5. The
Respondent number 5.
respondent number 5. The petitioner is aggrieved. With the order dated 3/7/23, issued by the Director of Education, BTC, Kokrajhar, allowing the respondent number 5 to hold the charge of headmaster of Nichila Mari LP school.
Yes, Lord.
LP school.
So ME school now.
ME school.
Yes.
Under the ME school. Full stop. It is the case of the petitioner that the respondent number 5 is junior to the petitioner, and as such could not have been allowed to hold the charge of headmaster, overlooking the seniority of the petition. Full stop. Next paragraph. The petitioner's counsel submits that no, next para. The petitioner's counsel submits, no, that next para. The case of the, no, the petitioner's counsel submits that the petitioner's seniority, no, the submits that the Nila Chamari, whatever, that the LP school
Yes, Lord.
has been amalgamated with the Nichila Mari ME school
Yes, Lord.
on
On 18. 22/1/2018.
22/1/2018. And in pursuant to clause 16 of the scheme for amalgamation and merger of different schools issued by the Government of Assam Secondary Education Department, comma, White Office Memorandum dated 3/8/2021, comma, the teachers of the two amalgamated schools could not lose their seniority. Huh? Clause 16 of the OM dated 3/8/2021 is reproduced here and below as follows. Page 76, okay, at the bottom. Huh? Next para. Next para. The petitioner's counsel submits that interestingly, the seniority of the petitioner has been counted from the date of amalgamation of the two schools. That is date
22/1/2018.
22/1/2018, while the seniority of the respondent number 5 has been counted from the date of initial appointment of the respondent number 5 in Nichela Mari ME school,
Yes, Lord. He was appointed in ME.
comma, that is on 24/1/2015.
Yes, Lord.
Next paragraph. The petitioner's counsel submits that if the petitioner's seniority had been counted from the date of his initial appointment in so and so LP school, comma, the petitioner would have been senior, comma, as he had joined the post of assistant teacher on 20/10/1993. Next paragraph. The petitioner's counsel submits that in terms of the seniority list of assistant teachers of the amalgamated Nichila Mari ME school made by the PEO Khoirabari, White notification number ASE -481/2016/164 dated 3/8/2021. That is at page 69. The petitioner is shown at serial number 2, while the respondent number 5 is shown as serial number 3. Is it?
That notification date will be fixed.
No, I've said because there's a notification mentioned inside. Okay, just say, don't say that, whatever I said, just read that paragraph. Now, in terms of the forwarding letter, you can just say, in terms of the forwarding letter dated 7/6/23, change this, huh? Change everything. 7/6/23 issued by the DEO Udalguri. Okay. The seniority, the combined gradation list of the amalgamated Nichila Mari ME school shows that the petitioner is at serial number 3, while the respondent number 5 is at serial number, no, is at serial number 2, while the respondent number 5 is at serial number 3. Correct?
Yes.
Good stuff. Next. However, in para 6 of the affidavit in opposition filed by the respondent number 3 on 14/8/2024, it has been stated that the district authority had sent another gradation list of the school which has been reflected in the report of the block elementary education officer, Hoira Bari, wide number KBE/MISC 15/8469, dated 2/5/23, wherein the name of the petitioner is found at serial number 5, while the name of the respondent number 5 is shown at serial number 3. Next paragraph. The petitioner's counsel submits that the seniority of the assistant teachers having required to be counted from the date of their initial appointment in the erstwhile schools prior to the amalgamation, the petitioner should have been made senior to the respondent number 5 and accordingly been given the charge of headmaster of the amalgamated school instead of the respondent number 5. Correct? That's your case? Next paragraph. Next. Miss Learned counsel for the respondent number 5 submits that there is no infirmity with the decision of the respondent authorities in making the respondent number 5 the in-charge headmaster of the school, keeping in view the fact that the respondent number 5 is senior to the petitioner in service. Next paragraph. Mr. B. Chowdhury, the learned counsel for the BTC, submits that the entire issue of seniority may be decided by the director, BTC, in as much as there seems to be a contradiction in the seniority list submitted by the district authorities on 2 occasions. Mr. Tamuli, learned counsel for the petitioner, and Ms. So-and-so, learned counsel for the respondent number 5, submit that they have no objection to the same. Next para. In view of the consent of the parties, the director BTC shall examine the issue as to whether the petitioner or the respondent number 5 is senior in the amalgamated Nichalamari ME School. And as to whether the seniority has to be counted from the date of initial appointments in the school or the date of amalgamation. It cannot be date of amalgamation. Date of initial appointment in the school, huh? School. Acha, one thing you write also for her. For her you write. She also submits that the respondent number 5 was given the graduate scale of pay from when?
He was appointed in 2015. as,
From the day she was
headmaster.
appointed, is it? No. Nothing like that. Okay, cut that. She doesn't. She don't know. So what have I said? The director BTC shall take a decision on the petitioners, shall take a decision on the issue within a period of 1 month from the date of receipt of a certified copy of this order and give reasons as to the basis for the decision to be taken by the respondent number, by him. The writ petitions accordingly disposed. That's all. Acha, before that, it is also made clear that the impugned order dated 3/7/23, allowing the respondent number 5 to hold the charge of headmaster of the school will not be acted upon beyond the period of 1 month given to the director BTC to take a decision in terms of the order passed today. Full stop. That is, the impugned order shall be in operation for 1 month with effect from the date of receipt of this order by the director BTC. The writ petitions accordingly disposed.
Item 53.
May I please, Your Lordship. Lordship, the matter is for non-release of pension by the disbursing authority, Lordship, that is Bank and Treasury, Lordship, since the date of
Yes,
my
madam, what-
Lordship.
May it pleases you, Lordship, here elementary education name has been reflected in the cause list, and your Lordship, it is wrongly reflected elementary name. Instead of that, your Lordship,
It is
second.
secondary.
Yes,
Lordship,
your Lordship.
actually, Lordship,
Kindly,
here the main respondents are the Bank and the Treasury. Lordship, pension was sanctioned to my husband.
ji ho.
Thereafter, Lordship, after his death, Lordship, it was not released to the,
Why have you claimed family pension after 12 years after the death of your husband?
Lordship, she repeatedly approached, Lordship.
I don't know. We'll wait. No hurry. You are suddenly in a tearing hurry. You want to finish the 100-meter dash while you could wait 11 years. Right. The petitioner's counsel, the petitioner's case is that her husband retired on 31/12/91 and died on 11/7/2011. Full stop. Though the petitioner's husband was receiving pension, as the petitioner's husband was receiving pension, the petitioner was expecting to be paid family pension, which has not been done till today. Full stop. Next para. Ms. P. Das, Learned Counsel for the Secondary Education Department, submits that as the cause list has made an error in reflecting SC elementary education instead of higher education in
elementary education name has been reflected instead of secondary education.
actually, instead of secondary education, not higher, instead of secondary education, she needs further time to obtain instructions in the matter. Full stop. Ms. P. Das is accordingly granted 3 weeks' time to obtain instructions as to why family pension is not being paid to the petitioner, who sub-registry to correct the cause list and reflect
yes.
SC secondary education. This is a matter of the 3 weeks, yes.
Here, Lordship, the bank is the appropriate, proper respondent, Lordship, and bank has not represented, Lordship.
You file an application for treatment.
Lordship, no, Lordship. It is, the cases,
Actually, they are a party already.
Lordship, already party, Lordship. I served notice to party also, Lordship. Lavazima order, there is one Lavazima order, Lordship.
Yes, your lordship, here bank is the main role, your
Okay.
lordship.
Right,
Department has no role, Lordship.
We have no role.
notice upon, has been served upon 1 and 2. Who is 1 and 2?
Lordship, State Bank of India, Lordship,
1 and 2 is State Bank.
Centralized Pension Processing Center, and the branch manager, State Bank of India, Lordship.
Don't they have a standing council, State Bank?
Lordship, there is panel.
There are
advocate,
panel advocates
Panel advocates, Lordship.
for State Bank.
Only they will redress the issue, Lordship.
Next, you're right, huh? Next, you're right. Office note indicates that. No. The Lavazima
Nine
court
words.
proceeding dated
Nine years,
20/09/24 states that
Oh.
notice appears to have been served through Dusty upon the respondents number 1 and 2. And as such, service in respect of the respondent number 1 and 2 has been completed. However, no one appears for the respondent number 1 and 2 bank.
I'm appearing for 4, respondent 4.
I've already reflected.
Yes.
Ms. R. M. Barwa appears for
Respondent 3, your lordship.
respondent number 3, huh? Mr. P. Saikia for 5, huh? What to do?
Lordship, respondent number 3 will take, 3 may take instruction, Lordship, the treasury. Normally, Lordship, treasury forwarded the PPO to the bank, Lordship.
Next para. Ms. R. M. Barwa shall obtain instructions as to why the family pension has not been released to the petitioner
Other respondents.
through the respondents number 1 and till date, and give a report on the next date.
The date may be fixed, Lordship.
Give April after Bihu.
Deeply obliged.
Obliged, Lordship.
Item 24.
Here, my lord, respondent number 8 has filed another writ petition.
Who has filed another writ petition?
Respondent number 8 of this case, my lord. The lordship has fixed this matter along with this, my lord.
You are challenging the appointment of the respondent number 8.
No, my lord, they are asking for direction to pay the, release the salary, my lord. Their salary has not been released.
No, 24, no?
Respondent number 8.
So why is this respondent number 8 a party here? You're challenging his appointment as a tutor or what?
My lord, he is the, actually, the person, who said he is the headmaster, but ultimately he was appointed as a tutor. If he would have been the headmaster, then all 4 recommendations would have been.
No,
just-
why are you making him a party here? That's my question. Why have you made him a party, the respondent number 8?
My lord, he is also a language teacher.
So you are challenging his provincialization.
So actually, over here, I'm challenging my cancellation of provincialization.
Then why are you making him a party?
Because other 2s are left, leaving me, cancelling my provincialization only.
Okay. They're senior to you or junior to you?
My lord, one is junior, one is senior.
Who is junior to you?
Respondent number 7 is junior to me.
So then respondent number 8, there's no problem with it. Then
Let him complete. No, but only one thing is, my lord, is not that I challenged him. He's otherwise a kind of a former respondent over here.
why? How performer?
Why I'll tell you,
You
because
tell-
there was a recommendation by the district for 4 persons recommendation. Admittedly, more than 100 students are there. So if we take the headmaster and another 3 teachers, all 4 recommendations should have been adjusted. Over here, what they have done, they have only done 3. Because of that, I was considered. Headmaster was also considered as a language teacher, me also language teacher, and 1 science teacher. The person R7 approached this honorable court, challenging my appointment, saying that I could not have been appointed as a language teacher because he is a social science teacher. So ultimately, there was a minutes in the government side, my lord. And over there, they have got, after that filing of the writ petition in additional, we have filed that. Over there, they said, this is the situation. We have found 2 language teacher. One is junior, so he should be removed. But before that, a procedure should be carried out, including hearing of the person. And they did not talk about the more than 100 students. And according to the act of RT Act 2009, with the schedule 19 and 25, that 4 teachers should have been there. Without saying that, they said in respect of 3 teachers. Now, what is my contention? Why I have been picked out and my provincialization being cancelled in the name of R7, because he cannot be a social science teacher whose appointment was as a additional science teacher. In fact, record shows, though I was teaching all the subjects, including social science.
Okay, what is to be done today?
Otherwise, I'm praying this matter may send it back to tribunal. Yes, they are disputing their appointments and all these things regarding evidence is required here. That is why I'm saying.
No evidence. What I'm saying, only thing, first of all, you said both the cases should be taken together.
My learned friend taking this matter under review, Lord. It's actually not correct in fact, Lord. In this matter, my lord, I'm the higher secondary science past teacher, my lord. I joined as a higher secondary science teacher, admittedly, my lord. District Scrutiny Committee recommended me in the subject of social science teacher, my lord. Then, my lord, the SLC provincialized 3 teachers among the 2 language teachers and 1 mathematics science teacher. He was very happy. Then I approached before this court and made them party, my lord. They filed affidavit and this honorable court recorded. Admittedly, the present petitioner is a language teacher, my lord. Then thereafter, I made an appeal before the authority concerned. After authority concerned, I found that, yes, admittedly, I am the social science teacher, my lord. He is a language science teacher. And subsequently, my lord, the second junior most language teacher, this cancel, my lord. My lord, this order absolutely, my lord, squarely covered in this case. In fact, the petitioner has no case in this matter. This honorable court has held that you cannot fight with the language science teacher or social science. It's a different subject. But you fight with the language teacher since you are a second teacher and first teacher. So admittedly, you're junior most, you're not attended. But no, this order covered my lord.
He's language teacher.
Yes, my lord. My learned friend, one of the council members, squarely covered my present case. Can you have a look, my lord? My learned friend is still aware of this case, my lord.
He's saying no.
No, I did not. I admittedly, my lord, he is appointed
my lord,
as a science teacher.
And my lord,
How can he be a social science teacher?
I will say, my lord. This order, my lord.
It'll take some time.
Yes, it takes some time. The lordship will fix for final hearing, my lord, in this matter.
Teachings are complete.
My government has not filed any affidavit.
When are you filing? Are you filing? That won't do. That won't do. That's the normal thing that you do. Huh?
2 weeks they may be given, my lord. After due vacation, lordship.
Okay, Mr. PK. is granted. 2 weeks time to file affidavit in the position. Huh? 3 weeks. PK Bora is granted 3 weeks time to file affidavit in a position on behalf of the Elementary Education Department. Are you filing anything? No. Ms. R.M. Barwa submits that the SSA will not be filing any affidavit. This is the matter.
On 24th of April, my lord.
Okay. 24th April.
April.
Item 25.
My lord, instead 24th, could it be 29th? 29th of April.
Why 29th? Why not 24th?
My lord, 24th, possibly I'll be out of state.
29th.
Yes.
Okay.
That
Deeply
matter also come along with this.
Huh?
That matter, my lord.
Okay, list the matter along with. Why do you need this? What will confuse the issue?
Lordship has fixed it. That is
Huh?
It's different.
Yes, it's different. It's a different. You confuse. Why you want to put together? I don't.
order is that is.
I think it is last order was issued by, passed by my lord only, where it was said that this matter should have been denied.
Acha,
Yes, that-
really?
yes.
Okay, list this matter along with WPC. Just show me that.
I think that order is by my lord.
No, not this. No, the small one. The small one. The small one. List this matter
Actually,
along with 948/2025. That what is that number? Expedition number? Correct.
deeply order.
May it please your lordship. In this case, although the irrigation department has filed an affidavit, but that affidavit is neither here nor there. They filed the affidavit saying that they'll file a detailed affidavit if required. So the director has filed that affidavit, otherwise the affidavit should come from the government, because it is the government who has rejected now.
Yes,
Yeah.
who's appearing?
I'm paying.
Equalization of pay.
Yes,
Yes,
sir.
So who is going to actually finance department or what?
Finance department is also required to file the affidavit, and the government.
Our affidavit is ready, but as per our affidavit, but all, as per the OMs and the higher education department were asked to resubmit the proposal, because now from what I've observed, they have already rejected the pre-proposal. They have not resubmitted the proposal to the finance department.
No, it is not a case of resubmitting it.
Mr.
Altogether,
Das.
they have rejected.
Because I have filed affidavit by the director, madam, and.
Your affidavit is very cryptic. There's nothing. You're just saying that.
As
You're
per
just
the
saying
OM,
that
madam.
the equalization of pay needs to be rejected. That's all.
No, as per the.
You have not
OM, my
given
lord,
any, huh?
In the OM, my lord, there is certain period was mentioned, my lord. 96 to 2005 and 2006 to onwards, my lord. And he completed, the petitioner completed PhD prior to 96. That's why, my lord. He doesn't come under this zone, my lord. That was the reply I have filed to that.
My entire case is that he has not gone through the brief properly. My entire case is that equally situated, my juniors have still the march over me in terms of pay. So I am claiming a stepping up of pay, because we are equally qualified in spite of
But
that.
you got your.
So that will not come into play. I'll clarify right now, your lordship. That notification is in respect of two groups of PhD holders who have acquired PhD in two different periods of time. That is during 95 to 2005 and 2006 onwards. So if there is a disparity between these two groups who have acquired the PhD and earned the increments during that period, that OM speaks of parity with them. But I'm altogether saying a parity in stepping up of pay with my juniors. Right through from very beginning, I was drawing a higher pay, but because of a special increment given to them for obtaining PhD, they have been drawing higher pay than.
But you had already got it prior to joining.
No. In fact, this honorable court and the department itself has given.
Anyway, you
The-
file your affidavit. And so you're not going to file any other thing.
My lord,
Are you sure? I'm going to record.
my lord, not record.
You
this
cannot,
time,
you see, you cannot file something and later on say that I want to file something addition. You file everything. Don't come halfway. And as per the decisions of the court, writ courts, a person cannot hide facts from the court. You have got to bring everything on record.
my lord, I'll go through my lord once. Then, if required, my lord, I'll file another one.
I've already filed lordship. I'm appearing for UGC.
Supposing they don't file, so you keep on standing with him only.
Our stand will be there, whatever they allow, we're going to give.
No,
Okay,
your
right.
lordship, I'll just like to make one submission. It is that college, they're required to produce the factual data because similarly situated persons were given the benefit of stepping up of pay with the juniors. So therefore, they has to bring the facts, your lordship. They can't say that I can't pay.
Forwarded there, but it's not accepted by the higher.
It's a specific case that 3 persons have been given of that same college. And
Why don't you make a RTI application and ask your information what you want?
No, your lordship.
You cannot ask the High Court to make a roving inquiry on your
I'm
behalf.
not saying that, your lordship.
Because their case is that they have forwarded
Yes.
whatever you have wanted. It has been rejected by, not by them, but by the authorities, by the department. So then, whatever documents that you want in support of your submission, that similarly placed persons have been given, then you take it from them.
I have already
Those
stated so
persons-
in my petition, your lordship.
You have stated, you ask them you ask them copies of what documents you want.
What I have seen, my lord, from this, from the petition, those persons have acquired their PhD after 2006. My lord.
After?
2006. That's why they came into this zone.
After they came into the, after they came into employment,
Yes, my lord.
is it?
Yes, my lord. They did
And he had it before joining.
No.
Not before.
No.
my lord. He acquired on
If he
91.
wants to argue, he can argue. If he wants to argue his case.
No, I want the affidavit of the finance department. That's what. Right, Mr. H. Ariha submits that affidavit of the finance department is ready and the same will be filed within a week. Close the matter after a week.
Appearance with record.
Oh, wait, Mr. S. Das appears for
Higher education.
Higher Education Department. Miss
Dr. P. Agarwal.
Dr. B. Agarwal appears for
UGC,
UGC.
R6.
For? That's point number 7 and Mr. H. Ariha for so, huh?
5.
Do you need to show the order copy to your thing, to your
You
client?
need to submit it.
Okay. That's important then.
Similar.
Same.
Two different persons.
Out here also.
So whether he's filing this affidavit or that can be.
I don't know. He's okay, right.
I
Mr.
have
A. Das submits that
If required,
he needs further instructions as to whether an additional affidavit is to be filed.
Yes.
Accordingly, Mr. A. Das is also granted a week's time, or make it 2 weeks time, both of them, 2 weeks time, to file additional affidavit, if required.
Deeply.
1957.
Makes sense, your lordship. Lordship, matter relates to withholding of increment. Meanwhile, what the basic issue involved here is that respondent number 5, who is the acting president of the governing body, he passes remark, and now on the basis of that, DHE acts on it and he is withholding my increment. That is the short one. And
So
I'm
where's
telling
the-
you
where's the
personal
person?
party?
Where's the other side?
In this matter, lordship, the affidavit has not.
I'm seeking some time, my lord, for an affidavit.
Mr. S. Das, Learned Counsel for the respondent number.
I'll be appearing for my lord. One, two, 1 to 4, my lord.
1 to 4
1, 2, 3, 4.
is granted.
3 weeks time maybe.
3 weeks time to file affidavit in a position. No one appears for the respondents number 5 and 6. This is the matter of 3 weeks.
Here also, Lordship, they've sought for time to file the affidavit. Here, the disciplinary proceeding was under challenge. And Lordship, we have
Disciplinary proceeding.
Lordship,
What do you mean? How can you, what do you mean disciplinary proceeding?
Malad, they initiated a disciplinary proceeding and this order was pleased to, Malad, in the interim, has granted that no course of action shall be taken pursuant to that. They
Huh?
initiated, Lordship, they initiated in disciplinary proceeding against.
They are challenging what? A show cause notice or what?
No, Lordship. Lordship, here what has happened maliciously, respondent number 5 brings in allegations to initiate a disciplinary proceeding. Well, meanwhile, Malad, I have approached the court, Lordship, that was on the basis of his malicious action.
How do you say it's malicious?
Lordship, his total indulgence in the matter and he has been making remarks that, Lordship, on the basis of, Malad, I was given the financial powers. I was utilizing it for the purpose of running the administration and the college. He makes a remark to the DHE and says that, no, I have been misutilizing the funds, whereas the entire thing, audited funds, audited balance sheets I have produced before the
So
audit.
that will be taken care of in the inquiry.
Lordship, that is what.
Then
The matter is there at the stage, Lordship, but we had stated that this allegations of respondent number 5, we had made him a personal party over here. He is acting as a governing president. He passes the remark to the thing and he never takes resolution in the governing body.
no, but how can you challenge a show cause notice?
No, no,
I fail to understand.
Showcase is not there, Lordship. His
Huh?
actions, his malicious actions has resulted into this. Lordship.
No, we do not. How can that be? Everyone will say malicious action.
Lordship, his actions are
Let us,
demonstrated because-
any show
because
cause
of-
notice issued to you.
Lordship, that has been.
Let us see.
Lordship, it's at page number 46. Lordship.
46. Yes.
In exercise, Lordship, you have made it.
Yes.
In exercise of powers conferred by the government notification this and this, the undersigned hereby ask you to show cause under Rule 9 of the Assam Disciplinary as to why any of the penalties prescribed in Rule 7 of the opposite should not be inflicted upon you on the following charges. Whereas as the principal, you were mandated to abide by financial procedures as per Assam Public Procurement Act 2017 and Assam Public Procurement Rules 2020 regarding procurement work-related matter, it is seen that you did not comply with the state rules and had procured items in contravention to the rules like not making comparative statements and giving procurement order without following due process as per inquiry report submitted. Whereas as the principal, you were mandated to ensure compliance of the leave rules and report by any deviation of the rules, but it has been reported by the president governing body that you had supported unauthorized leave of Mrs. This and this by not placing the matter before governing body and allowing to engage any substitute teacher to take class on her behalf without any statutory executives, provision of such alternative teaching arrangements. Whereas by virtue of being the principal and you are also the secretary of the governing body, as per the relevant rules, you are supposed to bring the unauthorized absence of the governing body, but the governing body was kept under unauthorized absence of judicial and press.
Yeah, not given a proper.
Lordship, that has
Then
my comment. Lordship, what was their intention to take away my financial powers?
we
I
don't
was the one.
know.
Lordship.
When they have said
Lordship.
that you had regarding procurement and work-related matters, you are not complying with the rules. The departmental proceeding will take care of that.
Lordship,
But I don't think you can challenge the show cause notice like this.
Lordship, there are certain
It will
other-
be a never-ending exercise. No, I don't think so. This cannot be allowed.
Lordship will have it after some time.
No, why should I?
Lordship, there is already an interim by this code, Lordship,
Huh?
that the coercive action should not be taken, Lordship.
Interim orders, I can always change it.
Lordships, that is what, Lordship. I'm
Unless
trying
you want to
indicate.
go bench hunting, that's a different.
No, Lordship, not at all, Lordship. My intention is that, Lordship, that the issue could have been placed before the recommendation, before the governing body for recommendation.
Look,
Then
Mr.
issue
Counsel,
was-
you see, you have filed a reply to that?
Lordship,
Have you filed a reply to the show
Lordship,
cause?
that is at 48 and 50, Lordship.
Page 48 and 50.
48,
You have filed a, now, after that, nothing has happened, is it?
Lordship.
Because there is a stay order.
Lordship,
I
only
don't-
coercive
can-
action to
can-
that effect, Lordship.
Huh?
It is
Coercive,
only
what do you
that,
mean? What is coercive? If the disciplinary proceeding is not coercive,
Lordship, what we were trying to do on the basis of this show cause notice, they were about to refrain me from taking any decisions in the authorities. and the court,
Naturally,
Lordship.
that's correct. Why should you be in a position of power?
Lordship, I'm the
You see, when there is any disciplinary proceeding issued, I mean initiated against any person,
Lordship,
usually they are suspended.
suspended. Lordship.
And not only that, even if the suspension is set aside, Supreme Court has said what in Ajay Kumar Chaudhary, he can be posted anywhere, transferred out,
Different place
not
of
to make, not to
different place of proceeding can
handle
be-
some work which can have an effect on the discipline proceeding. Here you want to be everything. You okay?
Lordship, I'm being the
No,
principal of the
nothing
college.
doing.
I have to manage the fund. It is
You-
not my
someone else will
recommendation,
manage.
Lordship.
The world
That
doesn't
any-
rest upon you. You're not
Lordship,
atlas.
NAC accreditation was only on the basis of my recommendation. Lordship. It was on that basis, Lordship, I can increase the funds of this college to run the administration.
Look, you can always challenge or you can always prove your innocence in a DP.
Correctly, Lordship. I'm not on that, Lordship, but the actions of this respondent number 5, his indulgence in the matter, Lordship, that is fitting. I made him a personal party and allegations has been made on this.
I filed an affidavit, and my lord, he is the principal, my lord, he is going on the dictatorship, my lord, without complying with the, my lord, any provision of the, my lord, governing body, my lord, he is not reported to the government, he is taking the decision on, my lord, we reported to the authority. Then the authority giving a show cause. Now, my lord, show cause has been challenged before the That is the case, my lord.
How,
Lordship.
just show me the law laid down by the Supreme Court or any court regarding whether a challenge can be made to a show cause notice.
Lordship, in that case,
No,
Lordship,
tell
will
me
pick
now.
the-
Now,
Lordship, I'm
you-
not that,
you-
because I have received the affidavit today in the morning itself.
No,
Lordship,
I'm not on
then-
the affidavit. I've not even read the affidavit. I am on your case. I'm on your petition. Can you challenge a show cause notice?
Lordship, then it has been in, one of the entire thing is that the arbitrary actions of the authorities as well as the one of respondent number 5. Well, the allegations are based totally on the personal vengeance of this person. That I had been
I don't
informed
know.
by.
I don't. That when a departmental proceeding can be initiated against you, as per the rules or the bylaws,
And Lordship, the issues
then as per the rules, then what is wrong?
Lordship, I'm not.
Whether the final decision is wrong or not, we do not know. Whether the actions are wrong or not, that will be decided by the authorities. We
Correct,
cannot go
Lordship.
into
Lordship,
what might be, what might not be. That is not the role of the writ court. Right. Heard, Mr.
H. Pitala.
Learned Counsel for the petition. Yeah, Mr.
H. Pitala. Lordship, I'm not that in the matter, Lordship. I'm in the second matter 3886. Sir. The first one,
386.
386.
Yeah,
The
yeah,
first-
366.
and both the matters are interlinked, Lordship. That is
Which matter?
the earlier one, 25 and 26. Sorry, Lordship, 26 and 27.
Huh?
The earlier matter, Lordship, the last matter.
Challenging only the notice, show cause notice.
The DHE and their actions, Lordship.
Ah,
Both the things-
So right now we're in 28.
28,
In 28, you're challenging the show cause notice.
Lordship,
And
here
in
also the-
27, what were you doing?
Well, Lordship, this DHE, my lord, he withhold the increment only on the basis of that.
That is different. That is
allegations of-
withholding of increment is different. I am on the
On the
issue
basis-
of
on the
departmental
same basis,
proceedings.
Lordship,
Huh?
that I have been utilizing the financial powers only on that grounds, Lordship, they had been issuing me this show cause. That's only on that.
No, that's not an issue. Right. What have I said? Mr. S. Das appears for?
I'll be appearing for 1, 2, 3, and 4.
Huh?
1, 2, 3, and 4.
1, 2, 3, and 4. Mr. T.J. Mahanta appears for
5 and 6.
5 and 6. That's all. No one else? Okay. What is all these judgments?
Lordship, that is what, Lordship. My senior Mr. D.K. Das is appearing in this matter. Lordship,
no,
will take it up on Monday itself, Lordship. He'll be there to satisfy my lords on these points, because this
No,
issue was raised at an earlier point of time also, Lordship. On that basis, Lordship was pleased to give the interim protections, Lordship, that no coercive action should be taken in these matters.
Not in these matters. This is when a departmental proceeding, otherwise all departmental proceedings will be stayed all across the India.
Lordship, for that purpose, Lordship, if I may take my lords, that the office memorandum issued by the government, which says that these issues has to be taken into consideration. That is at page number 64, Lordship.
60?
64. 11th of March 2017. This is the office memorandum, Lordship. These are the guidelines issued by the department while taking up departmental proceedings. It has been observed that the department proceedings are dealt with in a very irregular manner, resulting in court cases. It is seen that on the recommendation and request of the governing bodies, Lordship, here is the case, Lordship, the governing body has requested. Teachers and staff have been placed under suspension and the matters left at the stage of months and years, resulting in court cases and at times embarrassment went to the government. It has come to light that after suspension, matters left at the stage without any follow-up action, and government servant has to be reinstated with full pay, resulting in loss to the government and society. Lordship, here, if I may take my lords to the same show cause notice at page number 54. Lordship, the name of the person governing body itself has been reflected that on his recommendation, this show cause has been issued. Lordship, at page number 46, para number 2.
When is your reply? Let me see your reply.
Lordship. That is at page number 48, Lordship.
Yeah.
For a moment, if my lord pleases, can I take your lordship? to
No,
the-
no, just a minute.
And a detailed explanation is given to the effect that this lady who was suffering from, she was having some maternity leave. For that purpose, she was given them. Everything has been detailed in explained in detail, sir.
Okay, right. What am I saying? The petitioner's case is that he is a principal of Barkhetri College, Narayanpur, Mukalmua, in the district of Nalbari. The petitioners, the petition, the one Shri Raman Talukdar, who is the president of the governing board of the college,
Of the college,
the
governing body of the
college.
college. Lordship.
raised a number of complaints against the petitioner before the Director of Higher Education. Regarding spending of college funds without any approval from the governing body. The governing body had later granted approval to all the decisions taken by the petitioner. Next para. The petitioner's counsel submits that the petitioner had also filed complaints before the DHE against the
Respondent.
respondent number 5, who was the governing body, who was the president of the governing body of the college, for his unwanted interference in the administration of the college by the petitioner. However, the Director of Health, however, the DHE issued a show cause notice dated 7/3/24 to the petitioner. Pursuant to the allegations raised by the respondent number 5,
Lordship. That is at para number 2 of the show cause, Lordships.
without
Specifically,
any approval of the governing body.
Lordship, it has been stated, but it has been reported by the president governing that.
And without any preliminary inquiry or statement of allegations made against the petition. He submits that the government circular dated 11/3/2017. Where is that 11/3/2017?
Lordship, it's page 64, Lordship.
Issued by the Government of Assam, or issued by the Office of the Director of Higher Education, Assam. Envisages that the DHE cannot entertain complaints against a particular government servant without a resolution being passed to that effect by the governing body of a college. Pusta. He submits that not only has the DHE not taken any decision on the complaints made by the petitioner against the respondent number 5, but instead while order dated 23/7/24 removed the financial powers of the petitioner as DDO, by appointing the inspector of school Nalbari to temporarily act as the DDO of the college. Next paragraph. The petitioner's counsel further submits that though a show cause notice dated, where is that show cause notice?
Lordship is at page 46,
Show cause notice
7/3/2024, Lord. Page 46.
dated 7/3/24 has been issued to the petitioner under Rule 9 of the Assam Services Discipline and Appeal Close Rules 1964. Regarding imposition of regarding the imposition of penalties prescribed under Rule 7 of the aforesaid rules, how did I start the sentence? Pusta. To which the petitioner has submitted his reply by letter dated 13/3/2024. Denying the charges leveled against Pusta. Next. Show cause was notice was issued when?
7/3/2024, Lordship.
24.
24, Lordship. And Lordship, at para number 2,
Come to para 20.
para 20 of the writ, Lordship.
Yes,
Lordship, yes.
of the writ petition.
Lordship. That the petitioner submits, if I may read, Lordship.
Yes.
That the petitioner submits that if the chain of events unfolding in the present case is over, then it goes to show that at every stage there is a complaint raised against him by the president of the GB of the college without any knowledge of the GB of the college, but the same is made to look as if the decision to level allegation against the petitioner is made in a governing body meeting. Hence, interference by this court is required to thresh out all the impediments by directing the respondent author to complete the proceedings, hearing of which is completed on 3/4/24 under Rule 9 by taking into account the role of Shri Raman Talukdar, president of the college.
So you also want the departmental proceeding to be completed.
But that has to go, the conduct of respondent.
That's a
Him a
separate.
party.
Yeah.
Lordship, why I have made him a party? His interference and Lordship, the office member, when it says on
That
the
is for
recommendation
that
of
is for the authorities to decide.
Lordship, in my
You want the proceedings to be completed.
Lordship,
Who is for the GB? Who is for the?
It can be challenged only on the one ground, that is without jurisdiction.
Ah,
My lord, there are lots of judgment I place, my lord.
yes.
But here, my lord, they are, it is a very initial stage, my lord.
Correct. That's what I find.
Lordship,
These are the judgments.
There's so many
Just
judgments that.
Lordship, that is already a judgment which I have placed, Lordship. There, Lordship, it says when the governing body takes a decision, it has to be through a resolution. Here, no resolution.
that
You see,
is-
those issues can be thrashed out if the governing body has taken a resolution, whether it has been done without the
that is
governing
also,
body.
my lord, not
That will have
because-
to be proved
And Lordship,
when
basing upon-
when you examine the witnesses.
Lordship, and on the basis of the
You see, why I was reading your
Lordship,
reply, I was trying to find out whether you had taken a stand that no witnesses, no document, nothing of that sort is there. You have given your side of the story, that's all.
No, my lord, in
my
his own annexure, my lord, page 31, there is a annex C, my annexure C, my lord. But clearly the GB meeting held on 13/9/2020 expresses serious concern on the matter of spending money of so and so. That is already in page 31. So that will be looked into by the inquiry officer.
Correct.
So these are the three judgments I
Lordship,
placed, my lord.
I will see. Anyway, right.
And
The petitioner's counsel submits that the entire the departmental proceeding that has been initiated against the petitioner has been done on the basis of the complaint raised by the respondent number 5 without the knowledge of the general body of the governing body of the college. Hence, interference of this court is required to thrash out all the impediments, by directing the respondent authorities to complete the proceedings under Rule 9 of the 1964 rules, Rule 9 of the earlier rules there, Disciplinary Appeal Rules, 964, by taking into account the role of the respondent number 5 in the functioning of the role of in the activities conducted by him to obstruct the smooth functioning of the college by the petitioner. Next para. The counsels for the respondents, on the other hand, submit that the writ petition should be dismissed, as there cannot be a challenge to a show cause notice at the initial stage, especially when the petitioner has submitted a reply to the same and no final decision has been taken on the disciplinary proceeding that has been initiated, that has started. Next para. Mr. T.J. Mahanta, learned senior counsel for the respondent number
5 and 6.
5 and 6, submits that in terms of the decision of the Supreme Court in the case of Union of India and another versus Kunni Sethi Satya Narayana, 2006 12 SEC 28,
Para 15 and 16, my lord.
comma, Secretary, Ministry of Defense and others versus Prabhash Chandra Mirza, 2012 11 SEC 565,
Para 10.
and in the case of Special Director and another versus Muhammad Ghulam Ghosh and another, GHOUSE, Ghosh, 2004 3 SEC 440,
Para 5.
a writ petition, a writ jurisdiction is discretionary jurisdiction, and such a discretion is not ordinarily exercised by quashing a show cause notice or a charge sheet. In some very rare and exceptional cases, comma. No, that's all. Next para. He accordingly submits that when the petitioner has made a reply to the charge sheet, to the show cause notice on merits, and a final decision has not been taken on the departmental proceeding that has been initiated against the petitioner, comma, this court should not interfere in the proceedings in as much as the in as much as the letter dated 6/10/27 issued by the respondent number 5 to the Director of Higher Education, Assam, clearly reflects in para 3 that the governing body meeting held on 13/9/2023 expressed serious concern on the matter of spending of more than rupees 61 lakhs by the principal of the college without prior permission of the governing body. In an earlier case also, the petitioner had spent 32 lakhs without the prior permission of the governing body. I have heard the learned causes for the parties. The show cause notice dated 7/3/2024 issued to the petitioner under Rule 9 of the Assam Services Discipline Appeal close rules, 1964, hereinafter referred to as the 1964 rules. Framed the following charges against the petitioner, which are as follows: 1, 2, 3, 4, page 14 and 15 of the writ petition. Next paragraph. The petitioner made his reply to the show cause notice on merits, made a lengthy reply to the show cause notice on merits, denying. When is that? At page
48, Lordship.
48. That the purchases had not been made without the approval of the governing body. The petitioner had also
But page 52 is a hearing. Here, all the resolution which was given to me to give the financial power, that has been specifically resolution 8, 9, 7. All
This
resolutions.
will be taken care of, now.
That will be taken care of.
Then
That will be remanded and lordship can take. His authority
also
can proceed
denied
with that.
that he had violated any of the charges framed against him. Next para. In the case of Secretary, Ministry of Defense and others versus Prabhas Chandra Birda, Supra. The Supreme Court has held that ordinarily a writ application does not lie against a charge sheet or show cause notice, for the reason that it does not give rise to any cause of action. Full stop. It does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction / competence to do so. Full stop. A writ lies when some right of a party is infringed. Full stop. It further held that charge sheet does not infringe the right of a party. Full stop. In subpara, in the present case, in the present case, the petitioner has replied to the show cause notice, and in terms of the above judgment, the same does not give rise to any cause of action to the petitioner, as no right of the petitioner can be said to have been violated by issuance of a charge sheet, by the issuance of a show cause notice / memorandum of charge. Pusta. Next para. In the case of Punisetti Satya Narayana Supra, the Supreme Court has held that a writ jurisdiction under Article 226 being a discretionary jurisdiction, it should not ordinarily be exercised by quashing a show cause notice or a charge sheet. Full stop. In some very rare and exceptional cases, the High Court can quash a charge sheet or show cause notice, if it is found to be wholly without jurisdiction or for some other reason, if it is wholly illegal. Full stop. However, ordinarily the High Court should not interfere in such a matter. In the case of Special Director and another versus MD Muhammad Ghulam Gush and another Supra, the Supreme Court has held that has deprecated the practice of the High Courts entertaining writ petitions, questioning the legality of show cause notices, stalling inquiries as proposed, and retarding investigative process to find actual facts. And stalling inquiries as proposed. Full stop. It further held that unless the High Court was satisfied that the show cause notice was totally non-est in the eye of the law, for absolute want of jurisdiction of the authority to investigate into facts, writ petitions should not be entertained for the mere asking and as a matter of routine. The writ petitioner should invariably be directed to respond to the show cause notice and take all stands highlighted in the writ petition. In the present case, next para, in the present case, this court is of the view that the present case does not come within the very rare and exceptional cases for quashing of show cause notice or the departmental proceeding that has been initiated against the petitioner. There is nothing to show that the departmental proceeding initiated against the petitioner is without jurisdiction or that it is wholly illegal. Further, as reflected as a word. No, further, the petitioner in para 20 of the writ petition has made an averment that the proceedings, the departmental proceedings that had been initiated against the petitioner under Rule 9 of the 1964 rules should be completed. Though it has put a rider that the respondent number 5 should also be made a party to the said proceedings. Full stop. Next para. On considering all the above facts, this court is of the view that there is no ground to allow the writ petition or to allow the writ petition by setting aside and quashing the impugned show cause notice dated 7/3/2024 and the impugned order dated 23/7/2024 issued by the Director of Higher Education, directing the Inspector of Schools to temporarily act as drawing and disbursing officer. Full stop. The issue of whether the respondent number 5 should be made a party to the proceedings of the departmental proceeding is left to the discretion of the disciplinary authority. Which in this case is is a different matter altogether. Don't say that, huh? Left to this that is a different matter altogether. In view of the reasons stated above, this court does not find any merit in the writ petition. The writ petition is accordingly dismissed. The interim order passed earlier stands vacated.
Obliged.
Order, I think 29 and 30.
But even contempt application,
Yes.
contempt petition is of 2020. Till that, neither they have filed any affidavit nor they have complied with the order, my lord.
Where is that order?
My lord, order is at page 10, my lord. And the portion, relevant portion is at page 14, my lord. Para 8.
Para 8 and para 9.
Para 8 and 9, my lord.
Justice, here, the present commissioner has been newly imputed, and for him, on behalf of present Secretary Lordship, now NJ Khatna, he is appearing in this case, Lordship. Recently, he has appeared. Now, today he is on in that court number 12, the part case is going on. Now, he has informed me that they have filed an appeal against this order. So, right now, that outcome is, I am appealing for the earlier commissioner who has already been retired long back, Lordship. Now, he is appealing for the current.
What is the appeal number?
That I have no information. He is on
You
the-
find out, we'll wait. Otherwise,
Yes,
we'll pass
yes,
some
my lord.
order.
Yes.
We'll wait.
I'll get that. Yes.
Next.
Item 31.
Okay, allow me just 1 week time to get the clarification. Some confusion between the director and the principal. Some information has come, the principal has filed an number, but it is not listed. It is not listed his name. From telephoning instruction, I have got the telephone instruction.
Mr. S.
Try a week
Bora.
time.
Huh?
H. Buddha.
Mr. S. Bora, learned counsel for the BDC. Praise for 3 weeks time to file affidavit. In terms of the order dated, in terms of the last order, praise the Lord, this is the matter of 3 weeks.
Item 32.
This matter, social service is completed, Lord.
Service complete. Yes, what is to be done?
Should let the matter fix for admission. In the meantime, they can file their.
How much time?
Lordship, 3 weeks time, Lordship.
Mister?
You have to intimate the authorities also.
What is the name?
DJ Das, your Lordship, for response number 1, 2, 3, 4.
All the.
Is granted 3 weeks time to file affidavit of position. This is the matter of 3 weeks.
Item 33.
Well, in this case, I'm seeking a little accommodation. Mr. A.R. Wilder was looking after this matter. Due to some medical emergency of his mother, he has to leave the court.
I have already retired from service.
Huh?
I have already retired from service, honorable court directed to consider my case
For
for promotion to my next eligible post, my lord, head assistant.
now, what to do? Can you be given promotion after?
My lord,
Okay.
there is a direction.
No.
Yes.
You see, there is a judgment of the Supreme Court. The promotion can only take place when you start holding that post.
My lord,
Oh.
that benefit can be given.
Now
Notional
that
benefit.
that period that has gone.
Notional benefit.
Huh?
Notional benefit, my lord.
Notional benefit. Okay. Okay, right. Mr. Adjournment prayer has been made on behalf of Mr. A.R. Tabinda, who had to leave the court due to medical emergency relating to his family. It is also seen that no, so accordingly, leave this matter after 3 weeks.
2 weeks, my date may be fixed, my lord.
Huh?
Date may be fixed.
After Bihu, give a date.
Item 34. May it please your lordship. Lordship matter relates to releasing the pension of the petitioner lordship. Since 2021, she has not been receiving pension lordship.
Provisional to purchase. Provisional fund.
Okay. On the last date fixed lordship, this honorable court has directed the respondent to obtain instruction, my lord.
Yes.
Lordship. The concerned inspector of schools had submitted the proposal to the Directorate of Pension, Your Lordship. But it was found that we have sent it back again. Therefore, you are once again requested to take necessary action as per direction in para number 8 of the such and such, and resubmit the pension proposal along with the inquiry report and action taken report in the light of Finance Department notification number 27/122.
Give me a letter.
Waiving. It is on process, Your Lordship. It is on process. It will be sent. I had sought the instruction for them. So they had sent me the letter which has been prepared, Your Lordship. So
Can you give me a copy of the letter? I want it in my records.
No, it is not, signed letter lordship.
Yes.
They have just give the context of the letter, what they are.
So what to meet the grievance at the earliest, I shall ask the authority to expedite it accordingly, so that because this excess amount which has been drawn, it needs to be waived, and as per that finance notification,
There is some excess payment.
yes, excess payment was there, and it needs to be waived, and the concerned inspector of school needs to move to director, and director shall obtain the approval from the government. And after that only, the along with those letters, the proposals should be sent to the director of pension.
It will take some time.
Yes. Me too.
When did you retire?
Lordship, in the year 2021, my lord,
21.
21, my lord. And she is a lordship, single woman mother, my lord.
What is this?
Lordship may indicate a time frame and will produce them to by that.
Read code already framed the time.
This is a contempt case.
We are seeking for next 4 weeks time.
2 weeks time.
আপনার পরে needful to করব আমার তার আহিলে আমি করি
Another present the inspector of school, lordship, he is no longer holding the post 3D. Anyway, lordship, I will contact the present inspector, I will inform him, lordship.
Mr. B. Deary appearing for respondent number
I'm for
Director of pension.
Director of pension.
2.
respondent number 2.
Yes.
And Mr.
Lordship, I am for the lordship, respondent 1 and director of secondary education 1.
Name.
Mamta Hudai.
Huh?
I'm SMT 60, lordship.
SFT 60 appearing for respondent number
1.
1.
Yes.
Shall on the next date bring the letter sent by the concerned inspector of schools, Hailakandi,
Yes.
to the director, to the director of pension, to the directorate of pension, showing that a proposal has been made, showing that the proposal for payment of pension, along with all the required documents, has been furnished by him to the Directorate of Pension. I want a document. If the document is not there, he has to come
Yes.
and list the matter on, give it. Before Bihu.
Before me. Only that the pension, the paper date may be furnished to me so that I can transfer it to the.
It will be uploaded, you just download it.
May I please your lordship? This IOS file issuing the order of Deputy Commissioner Sonitpur, which is at page 8 of my IA.
Yes.
My lord, I was running on Vocational Training Institute, offering 2 courses in allied healthcare. Suddenly, Deputy Commissioner passed this order without giving me any opportunity of so forth. Deputy Commissioner asked the Joint Director Health Sonitpur to seal and close down my institute. Accordingly, on 15 July, personnel from Joint Director Health Sonitpur, they came, they sealed my institute. My lord, on that day.
Who is the peering for the other side?
My lord, all the government respondents appear. They were to file affidavit today. Last, this case was listed on 6th March.
Yes, this is with regard to sealing of the institution, his institution. He is running some kind of institution. No, you are giving what?
Vocational training.
Engineering.
No engineering,
What?
my lord. This is
Nursing.
healthcare, laboratory technician.
Or then it will be under health.
Health, yes. And
Why the institution sealed? What is the reason?
the reason is that I was running the institute without the NOC from the state government. That was the reason.
Is it required?
My lord,
There is a policy now, that you will have to have the.
Then what is wrong? If you are running the institute without the approval of the government, and if it is a requirement, then what is wrong with the action of the state?
my lord, may come on page Annexure 7, page
Of?
21 of my writ petition.
Writ petition. Give me the writ petition.
This is important. Page 21.
Page 21. Page 21. Yes.
My lord, Health Department issued one regulatory framework on 7th and notified it on 7th November 2023.
Correct.
It's a long. It's 8 or 10 pages, but I don't want to take time. The essence of this framework is that government said that they have the knowledge that institutes are imparting healthcare education. This needs to be streamlined. For this, now, after 7th November 2023, if anyone wants to establish any healthcare institute imparting education like BIC nursing, allied health, they shall first apply for LOI, letter of
Intent.
intent. Thereafter, after getting the LOI, they will apply, there will be one inspection. After inspection, NOC will be issued. After NOC, they can establish the institute. Thereafter, they shall have to affiliate to Shankardev University of Health Sciences, irrespective of the course they are running. Irrespective of the course they are running. My plea is that I am running a vocational course, vocational training course. It is neither a diploma nor a degree. Furthermore,
So your case is that your institute is not covered by this
yes,
framework.
My institute is not covered by this framework. Furthermore, my lord, I am associated with National Skill Development Corporation.
Skill development.
National Skill Development Corporation.
And laboratory work is skill development.
Yes, it's a part of skill development, vocational.
So laboratory work, does it include blood testing, all that?
I have the syllabus. Last time you
I'm
asked.
asking you, does it include blood testing?
No, he is the blood testing is the domain of pathologist. He just collects. He maintains the lab. He can collect blood.
He can collect blood.
Yes.
So what will he do? He's basically like Zomato. He'll go collect and give it here in the laboratory. Huh? Is that?
Maybe.
Or maybe.
Not right. He can collect blood. This is
Collect
part
is
of
what?
curriculum.
He will give injection and pull it out. He will, or what? Or he will just go and collect the capsule and give it. Okay, I'll give it to that thing, and then in the evening he'll bring the report and give back the report. What is his job?
This is approved.
Please enlighten me. Enlighten me. You've got to enlighten me on exactly what does a laboratory assistant do?
1 minute.
Or does?
The curriculum approved that is sample collection and analyzing techniques.
Oh, analyzing techniques.
Counseling the patient and preparing medical documents, medical and diagnostic supplies.
And he's got to be what? Medical diagnostic supplies. So he has got to have some science knowledge.
Yes. The curriculum is designed as that way. My lord, only allegation against me is that I am running the institute without NOC.
So you take the NOC, what is the difficulty? Or
I am not averse. My lord, I am not averse to taking NOC. My institute,
I think we need a affidavit from the other side. Yes. Why it has been seen. Basically, he says that he does not come within the framework, the provisions of the framework. But then I think you'll have to explain why he comes within the provisions of the framework and why he requires to take the LOI. That will have to come. We cannot decide this matter now.
My lord, I am suffering because I am paying salary to the faculties. There were 150 students. They have sealed my institute. I cannot enter and can do regular work like paying electricity bill, water charges. My lord, this IOS file for one order to open the institute. I undertake that I will not take classes. I will not take classes. I will not perform any academic activity till further order of the court.
Then what will you do with open rooms?
I have to
empty rooms. What will you do with open empty rooms?
No, empty room, not classroom. My lord, a principal's room.
Only principal's room.
Or principal, so that I can write the case book. I can pay. I can perform normal works.
He wants to open only the principal's room.
He can wait for another 1 week, my lord. The order was
that he
passed
can wait.
in July 2024. if I'm not wrong in the, I, Lordship will see page number 9. You can wait for another 1 week, my lord.
You see, only thing is that you all also should hurry up, take a decision as to
My lord.
what you are going to do with it. Because this has come since October and you have not done anything since then.
Let it be on Friday next, my lord, at least. I will come up with something. In fact, it is the
Friday
vote, it is the deputy commissioner. He is only implementing the scheme of the health department. But it will have to be.
Maybe, but then, yeah, so,
My lord.
but you see, when he takes a decision to lock up an institute,
Yes.
there has to be some basis for the same.
Yes.
So where is
No,
that?
that they have submitted that the particular institute, the petition I hear it, they doesn't have the, my lord, affiliation of the Sankadev University, with according to the, my lord, policy of the government. All such institution we are already running, my lord, they will also have the. have
His
to-
case is that he doesn't come within this framework. He says
He-
that
it-
if he
it-
comes within the framework, then he has to have affiliation with the
He will
Sankadev.
come under the Allied Health Service. my lord. It is
So
there.
you please give an affidavit that he comes within this.
Lordship.
Okay, right, in the main writ petition or in both, can you just write? The petitioner's case is that the institute that has been sealed by the district commissioner does not come within the invert commas regulatory framework of the nursing, pharmacy and allied health science sector in the state of Assam. Invert commas closed. As provided in the notification dated 7/11/2023. Page 21. On the other hand, Mr. B. Gogoi submits that the petitioner's institute comes within the notification dated 7/11/2023, which requires that the institute should be affiliated with the Shankar Dev University. Health University.
Sankadev University of Health
Sciences. Shankar Dev University of Health Sciences. List the matter on
28th, my lord, I will have
28th.
28th of March.
28th March, by which date the respondent should file their affidavit.
Or instruction, my lord, whatever is there, I will place.
Whatever, all
Detailed
plain
instruction.
instructions by the next.
I will do.
Item 46.
For demand report, service upon respondent 7 is completed. 2/9/2000.
Huh?
2/9/2007 notice was issued to all 1 to 6 respondent. Government Education Department has issued, received 7 years headmaster. It was directed by your lordship to take a step of our HR post, which is as per law demand report, it is completed service. Meaning thereby service is completed. Now they will be listed for admission.
Who is for the other side?
Elementary education.
Elementary Education Department.
They are to require to file. It will interesting case, my lord, affidavit will be required.
His case is that basically he is not been allowed to join the amalgamated school.
And the problem she is also having, that is not.
Huh?
That we are also, because without result, we have not joined, but neither discipline action is taken, nor allowed me to join, my lord. Now, in the meantime, my lord, my
You're not allowed to join since when? When was it amalgamated, the school?
amalgamation was done in, actually, she could not come from 13 onwards.
2013 onwards.
The psychiatric disorder. That is correct. I'm coming on that right point. Psychiatric disorder. In the meantime, she did not go. In the meantime, the school was amalgamated. Her name should have been also forwarded.
Oh, so prior to amalgamation, she did not go.
Yes.
Then what is your case?
Nothing.
So my case is there, without.
There.
Please, I will come. Now, my lord, my case is now.
You will
this
come,
from
you will come when?
No,
It's like you're coming
But-
from,
But.
you're coming from Shillong to Guwahati, but you're taking the long route through Kanyakumari. You come direct.
That is
Ah.
all right. But I am in the box. I am in the strength of the school. I am a permanent member. I may not be. There is no discipline action. Anyhow, my lord, what your track is being changed now. Because already she would have even working also got retirement is over, because that is over. That is why.
She would have retired when?
This year.
This year.
But only because she has completed successfully 19 years. 19 years. 19 years. Will we praying before your lordship, not for reinstatement now, anything? Because as discipline procedure has not been, at least it will benefit she gets by way of pension or what that will come, will discuss. Because let the affidavit comes first.
Today is just come for orders, my lord. We will-
That's right. I'm not here. I'm praying list for my admission hearing. In the meantime, they can file affidavit.
Mr. A. Fugan, Learned Counsel for the Elementary Education Department is granted 4 weeks time to file affidavit in opposition. The petitioner's case is that she has not been given salary since 2013, as she was not allowed to join in the amalgamated school. To stop. The petitioner's further case is that she had been on leave, unauthorized leave. No, she had been absent. She had been unauthorized absence from the school, from her school prior to the amalgamation of the school due to psychiatric problem. To stop further, the petitioner's retirement year would have been this year.
That's what.
Listen,
Only one more line may I pay for this. Neither, because she was working for up to 91 to 13 regularly. Neither any disciplinary or any notice or nothing has been because if person is unauthorized, then also something is to be given.
okay, that school that she was, that was the government school, provincial.
Yes, Punjali school. He was getting salary, my lord.
He submits that there is no order issued by the government to the effect that the petitioner's service was terminated.
That's not nothing. And it is the strength of your lordship's order, I got real salary.
Yes.
Yes.
Where is the no laddu and for your friends and all out here? You should have given them.
Laddu.
Laddu, samosa.
Already did it. Already they have consumed.
No,
They have forgotten.
They have forgotten.
That's the problem.
Tell them to file affidavit fast.
Yes, my lord. Some things he is expected from this honorable court.
Lordship, here the filing number is Lordship 3512 of 2025, Lordship.
Acha, okay, right. Mr. SMT, Learned Counsel for the respondent submits that the order dated 26/9/19
2019.
passed in WPC 4447 of 2014 has been put to challenge by way of WA number
35.
This is the filing number, just
Filing
filing
number 3512 of
has
2025.
been put to challenge by way of appeal from other filing
Number
being
3512
3512
public 2025.
or oblique 2025. However, the same has not been listed before the division bench.
Yes, it will be
Then,
listed. It will be listed by,
huh?
it will be listed, I think by next week. it will be-
After 5 years.
No, the new, they have implemented the new income only recently.
So,
Lordship.
what about the condonation of delay application?
Even
That was also filed, I think. That was also filed.
Find out.
even
Mr. SMT shall provide the
Lordship, here, NJ Khatner appeared for the new income. and for the earlier, so-
the registration number of the application for condoning the delay in filing the appeal by the next day. List the matter when? Next week,
yes, well,
After 10 days, Lordship.
or 10 days, okay. List the matter on 3rd.
of like-
for the 3rd of April.